correction again. Just yesterday I mentioned that the correction for hotel come restaurant already allowed by your lordship, but the record not say the kindly submission.
Lordship.
And I have to start the copy of others.
Lordship.
Come back tomorrow morning. Tomorrow there is court. This Saturday there is court, full-fledged court. Already declared long back. Only for this two or yes.
Small correction, para number 3.
Hand over. You hand over another slip also, please. You also hand over another slip. দেখে নেবেন কালকে যেন লিস্টে টু মেনশনে থাকে। Yes.
Lordship, with kindly from my Lord Justice Uday Kumar, I am mentioning it before the Honorable Justice Shobhasati Bhattacharya.
Yes.
Lordship, the matter relates to single bench with an extreme urgency that a notice under SARFAESI for recovery redeem of loan account has been passed, and I had been to the office. 30 days time was given. I had been to the office to deposit the check, but they refused, and last day for 30 days is on coming Tuesday, Lordship. So I want to deposit the entire amount. Lordship, may kindly heard.
To give the number, ask somebody to give the number, it will appear as to be mentioned tomorrow.
Lordship.
Give a notice to the other side if you can, Mr. Dhar.
Lordship.
My lord,
Lordship, I am deeply obliged.
I beg your lordship's leave to mention the matter read petition application habeas corpus 5 of 2025. My lord, today it is listed as item number 53. If it kindly be upgraded, my lord.
What is the matter about?
My lord, it's a habeas corpus application.
For the first time?
Indeed, your lordship.
So why didn't you mention earlier? Last day?
My lord, best today I have got the instruction.
No.
Lordship, may I mention serial 36 online, Lordships?
Ajay, the habeas corpus, in what context?
My lord, the petitioner is apprehending. The police did not take any kind of action. It's an.
Who is missing?
My lord, it's the accused is something who is missing. Yeah.
If you're not sure about your matter, please don't mention. Yes, Mr. Kanuri.
Lordship, Monday I mentioned this matter, Lordship. It is at serial 36 today, Lordships. The London single bench has admitted my writ petition but refused to grant interim. And Lordship, there is a recovery proceeding of around 12 crores of refund already granted to me. London single bench has given an indulgence, has admitted my writ petition, but it has been recorded. It is a case, Lordship, where refund was granted to me.
Mr. Kanuri, I mentioned before the next circuit, not possible now.
Lordship, only on interim. I will take 5 minutes only.
No. Interim order means we have to hear the merits of the matter. No, Mr. Kanuri, no upgradation. Yes.
Lordship, one indulgence, Lordship may given leave to the petition, Lordship. Otherwise, the filing section will not take up the matter for tomorrow.
Yes,
I am handing over it through my learned junior.
Yes, এটা এলে লিভ দিয়ে দিও, কালকে সিঙ্গেলে থাকবে। Yes. কল কর।
Number 1 for handling.
Accordingly, DR number 5 of 2024 with CRA DB 10 of 2025 with CRA such and such are disposed of by confirming the conviction of the accused on the counts of sections 396, 97 and 398 of the Indian Penal Code. However, the death sentence awarded in the impugned judgment in view of the offence committed under section 396 to the appellant is commuted to life sentence for the rest of his life without any option of premature release for 20 years, unless exceptional circumstances are made out to the satisfaction of the concerned court. Such sentence shall run concurrently with the sentences of rigorous imprisonment for 7 years awarded on both counts of 397 and 398. Thus, 7... Hey, ওটা অফ করে দাও। এই, ওটা অফ করে দাও। মাইকটা চলছে কেন? Such sentence shall run concurrently with the sentences of rigorous imprisonment for 7 years awarded on both counts of sections 397 and 398. Thus, 7 years of the life imprisonment shall be spent as rigorous imprisonment. However, keeping in view the fact that the appellant was lastly residing in Delhi and not a local resident and no source of income of the appellant has been disclosed, fine of rupees 5,000 on each count respectively under 397 and 398 are set aside. Time already spent by the appellant in incarceration, pre, intra and post trial shall be set off from the term of imprisonment, qua the period of 20 years of restriction regarding premature release of the appellant. The department shall immediately send copies of this judgment to the trial court as well as the superintendent of the correctional home where the appellant is now housed in order to ensure due compliance of the same. Thank you.
जो आधार कार्ड राशन कार्ड जो साइट
अनम्यूट किया हुआ है. Lordship, I am for the petitioner.
Oh. Yes, why is it appearing?
Lordship, this was the matter that was released
Single
to your
bench,
Lordship
very well.
yesterday. Yes,
Yes,
your
yes. We'll
Lordship.
repeat
For
that order
addition
in
to-
division bench.
Yes, your Lordship.
In this matter, initially an order was passed erroneously by one of us, within bracket Bhattacharya Ji, sitting singly, whereas the matter pertains to the division bench. Full stop. Learned counsel for the appellant seeks to produce certain documents which are furnished in the code below but not marked as exhibits. Full stop. Accordingly, leave is granted to the appellants to file a proper application under Order 41 Rule 27 of the Code of Civil Procedure, seeking leave to produce the said documents as additional evidence. As and when such application is filed, leave is granted to the appellants to mention the same for inclusion in the list with prior service of a copy of the application on the respondents. Full stop. We'll add one line. Affidavits in connection with the application, as and when filed, shall be exchanged in the meantime. Thank you.
Grateful, Lordship.
Next.
Number 5.
The accused as well as the lady has surrendered before the IO, my lord. Yes, in the recording, my lord. After they have surrendered, today their statement is recorded. The 164 statement, my lord. This is the report.
My lord, I am for the respondent number 8. Respondent number 8 and the lady jointly surrendered before the
Respondent number 8, you were saying from last day we have recorded wrongly. Respondent number 7 is that person, not 8. You repeatedly yesterday, last day you said.
in here it was 8.
Don't have a copy of the application. Look at the application. Why do you look at their communication? You are an advocate, you don't know who you are appearing for, and we have been wrongly recording. Anyway, both have surrendered.
Both have surrendered. Yesterday near about 4 p.m.
What is the stand of that the lady that she has gone willingly? We'll put it tomorrow as to be mentioned. Learned counsel for the state appears and submits that both the concerned Taposh Kundu and Sujata Bormon have surrendered before the investigating officer. Full stop. Their statements under section 183 BNSS will be recorded today. Full stop. Next para. A report in that regard is submitted and kept on record. Full stop. Copies of the said report shall be filed tomorrow in court by the state. Copies of the said statements given by the said two persons shall be filed in court tomorrow. Full stop. The matter will be listed as to be mentioned tomorrow for such purpose. Thank you. Thank you very much. স্টেটমেন্টটা একবার দেখে নি ফাইনাল রেকর্ড আছে কি এটা
This was a writ petition, my lord, which was taken up by the Honorable Single Judge.
Yes, item 6,
6.
public interest litigation,
Yes, no, my lord, it was filed as a writ petition, my lord.
converted to public interest.
Public interest.
We'll put it on the next circuit then. One day it cannot be.
My lord, since my lord,
What is the nature of the public?
my lord, I was my lord, taken aback, my lord, by seeing listed it before this honorable bench because we were told by the department that the file has been sent before the Honorable Chief Justice in the principal bench.
Chief, it was communicated to the Chief Justice. The Chief Justice last night, it was communicated to us that the Chief Justice has assigned it to the division bench here.
Grateful, my lord. My lord, in that event, my lord, if I can make one request, my lord, since a larger and grave public interest is involved, my lord, it directly, my lord, with the jurisdiction of courts, and 3 learned advocates have challenged this. So, my lord, if it can be taken up, my lord, tomorrow, probably subject to, my lord, the court functioning. Well, it's a very short
Court is
question involved.
functioning tomorrow. No.
As of now, yes. So, my lord, kindly takes it up tomorrow, my lord, at the first sitting subject.
Tomorrow we will take up only these matters which we have kept specifically. This
I won't take more than 10 minutes. My lord, But I have some urgency because we have.
It's a full-fledged court day. Some other learned APP has to be appointed then. You have to engage some other person.
The question I tell you, Lordship Millard, is whether by way of executive notification, the entire jurisdiction of 7 districts with regard to certain special acts, which according to the state government is being investigated by the STF, can be taken away and conferred upon a particular court in Siliguri. This is, Millard, the matter under challenge. Millard, according to us, this is an essential legislative function which cannot be done by way of executive.
Which act is violated? Bengal Agra is not violated.
Not Millard, it's Millard directly goes against Millard the spirit and letter of the BNSS and earlier the CRPC, particularly chapter 13.
Regarding territorial jurisdiction?
Regarding jurisdiction of crime.
Not issue, man. Take a long elaborate hearing, man.
Jurisdiction, then let it come up before the next.
Millard, kindly takes it up tomorrow, Millard. Millard, if let them make an undertaking that they will not act upon it for 7 or 10 days, Millard, I have no difficulty.
No, it will not, because the Chief Justice assigned it to the division bench here. So
I won't take more than 15 minutes. Millard, at least for so far as my interim prayer is concerned. After that, Millard, let them come up with affidavits if Millard thinks there is some merit in the matter.
yes, what do you say? For the purpose of interim order also. You can stay your hands for till the next second.
This is fine.
Oh.
That's the urgency.
Investigation going on,
That's
man.
the urgency. And even Millard, the constitution of the STF, since it's now converted into a PIL, Millard can also go into the question whether the constitution of STF is at all legal.
No,
or not.
Ms. Sharka, because it was rightly converted, now it appears. Because if it was a private dispute, we could have asked them what is your locus standi. But if it's a public interest litigation, locus standi becomes a bit diluted. So if there is extreme urgency, we have to take it up. But
The jurisdiction of the court has been taken away by way of executive notification.
Since 2019, the STF is working.
No,
on-
this notification, this notification is of 2025. What is she saying?
Yes, you have challenged 2025 notification and
The 10th February 2025.
no, 2025, not 2019, you were saying?
2016. 2016.
No, they are challenging a 2025 notification
Yes,
only.
yes, yes.
No, they were conferred jurisdiction 2025.
Yes, 2025. The jurisdiction of the courts taking away and conferring it to a court in Siliguri, that happens in 2025. And the constitution of the STF is in 2010.
We will keep this matter tomorrow, Mr. Sharkar, to arrange for someone to be there.
Grateful, Millard, extremely grateful.
Extreme urgency is pleaded on behalf of the petitioners. First of, let the matter be listed tomorrow.
Grateful, Millard.
এই ম্যাটারগুলি শুধু যেগুলো বলছি আপাতত শুধু এই ম্যাটারগুলোই রাখবো কালকে, হ্যাঁ, আর এর বাইরে কিছু রাখবো না। যেগুলো আজকে অলরেডি ডিরেক্ট করেছি সেগুলো দাও।
This is a renewal of suspension of
পরে ফাইলটা রেডি করে রাখো। Yes, Mr. Ganguly, you have prepared, if you could prepare. Thank you.
Taken over printout in the net.
Thank you. Yes, what are the circumstances? When last refused? 2024.
24, Your Lordship.
Yes, what is the matter about?
Your Lordship, conviction under section 6 of the POCSO Act, Your Lordship, almost 7 years in custody. Your Lordship,
Your sentence is 20. How many years? Sentence?
life, Your Lordship.
Life.
Life.
Yes, what are the mitigating circumstance?
So, Your Lordship,
Your age at the time of offense?
22, Your Lordship.
Victim?
Victim 2.5. 2.5. Your Lordship, may kindly appreciate my submissions that I. Your Lordship, at the very outset, I would like to submit Your Lordship that 164 statement of the VG, minor VG was not recorded. After 1 year, she comes to depose into the court.
2.5-year-old VG?
2-year full VG. Your Lordship, in the court puts certain questions to the VG. She is unable to, she answers wrongly.
164 taken after 1 year?
No, the deposition,
164 not taken?
not taken, Your Lordship.
Rightly.
Your Lordship, I may begin with the allegation, Your Lordship. The allegation is that on 17/12/2018, after taking rise, this particular minor VG along with her along with the niece of the de facto was playing. And then the accused comes, entices the niece of the de facto, takes the minor VG from there, takes her to a bamboo grove.
What was the age of the VG, of the niece?
Niece was at that time, your lordship,
Around.
6, your lordship, 6, 6, 7.
Well,
Now,
then
now, your lordship,
bamboo, then offense, then what? What is the mitigating circumstance?
the mitigating over here is that, lordship, all the apparels of the VG. Now, as per the FIR, it is stated over there by the de facto that he undressed the VG, the appellant, and what pant is there. However, from the PO, the apparel found is the seized is the frock. First, your lordship. After that, on that particular day itself, 17/12/2021, she is taken to the Dinhata Subdivision Hospital for medical examination, your lordship, before filing the FIR. Now, your lordship, over there, her wearing apparels are kept in by the sister in charge. The wearing apparels along with the vaginal swab and the rectal swab. Your lordship, 4 items were
The life streaming.
A live stream to off. Thank you.
Your lordship, 4 items. Your lordship, 4
My lord, item number 8, I appear on behalf of the appellant, my lord.
Yes.
My lord, I will not take much time, my lord. Some points I will specify, my lord. My lord, kindly come to deposition of witness number 6, that is the doctor who was senior, 61 year of age, my lord. He has stated in his statement, my lord, in his witness that on examination at 7:20 p.m. 26/12/2021,
This is
I
POXO Act. 6 of POXO.
my lord.
Age of victim.
6 years and he is the father, my lord. I did not find any mark of injury on her vagina, vulva, and perineal region of the victim girl. Hymen was intact. Vaginal swab was taken, my lord. My lord, he is the father, biological father of this victim girl, my lord. My lord, yesterday also I have shown, my lord, that a divorce case is going on between the parties. Relevant to that, I will hand over a judgment, copy of judgment, my lord, paragraph number 16. My junior will be handing over, my lord.
Ms. Dotto, how you and your wife are living separately?
My lord, in her petition, my lord, come to the petition, my lord.
Tell us. You tell us.
My lord, in her petition, she had stated in the divorce petition since 2015 they are residing separately. But my lord, again she has stated paragraph number 6 that the few days on 1st March 2022, a girl child has been born.
All this in her evidence.
In her with my lord, I have given the copy of the divorce petition. In the divorce petition, she has mentioned all this.
Where is the copy of the divorce petition? We don't find it. Give
My
copies
lord,
to them.
kindly come to page number 3, my lord, paragraph number 9. Page number 3, paragraph number 9. That your petitioner lastly resided with the respondent in her matrimonial home on 10
Yes, you have read
February.
it. Where does it say that they live together?
6, paragraph number 6 of page number 2. That after few years more, another female baby was born, namely Aravi Roy, daughter of Mithu Roy, on 1st March 2022. Paragraph number 6. And kindly, my lord, come to
No,
paragraph.
you come to paragraph 4 also. 4
Yes,
and
my lord. Paragraph 4.
Fourth, she says that many amicable settlement held, all in vain, no other alternative. Petitioner came and took shelter at her mother's house. After a few days, respondent again came to the house of your petitioner at the above pension place and address, and satisfied your petitioner. Both petitioner and respondent started residing. A child was, and 9, she says, last resided in matrimonial home in 2015. But
My
she
lord.
went back to her house and the husband went there and they lived together and the baby
My
was.
lord, flip to the and
So it's
another
not
thing,
contradictory.
my
Yes.
lord, page number 60, paragraph number 16 of my my lord, I have handed over the order, my lord. Come, my lord.
What order?
Similarly,
Judgment.
my lord, judgment. Paragraph number 16, page number 11, my lord. Similarly, in matrimonial disputes in between husband and wife, their minor child or children would be meddled and weaponized to wreak vengeance at the teeth of POXO Act to avoid the claim for custody by the husband. My lord, again come to paragraph number 16. After 17 it is, I am of the considerate opinion that POXO court which try cases like this in which an accusation of sexual abuse is made against the father of the minor child, especially when there is a custody dispute.
What is the date of the offense?
My lord, date of the offense is 17/7/2021, 18/7/2021, and they have lost the FIR on 26
17th or 18th, on 2 days, both days.
days. She has mentioned in her FIR
Achha,
on
very
2
well.
days.
61 years, whose age is 61 years?
No, my lord,
61 you did not say.
no, 6 years.
No, that is the child.
Yes,
Yes.
child and father. This is the father, my lord.
How was this angle portrayed before the trial court, this matrimonial dispute?
My lord, I am appointed by, my lord, the order of the honorable court, my lord. I did not have direct connection with the client, my lord.
You have a copy of the judgment. You don't have a copy of the judgment.
My lord, I have annexed that one, my lord,
No reflection.
with the application.
That is
I
what we are
also,
asking. You don't have connection with the client. How? What will that do?
my lord, I no, this point was not taken, my lord, during the time of judgment trial. My lord, there is no specific explanation of the delay, my lord, that the offense has occurred on 17/7/2021 and FIR was lodged on 26/12/2021. No sufficient cause mentioned, my lord. My lord, my client is in custody for more than 3 years and 7 months, my lord. My lord, kindly consider, my lord.
No, sorry, Ms. Dutt.
My lord, upon any condition, my lord.
No condition. Uh,
My lord, nothing is in the medical report also, my lord.
what? Nothing in the medical report. What
My,
medical report? Only hymen not ruptured. That is there. Hymen is intact.
my
Injuries are there in the medical report. Other injuries?
no injury written, my lord, by the
6 year
doctor.
may not be 6 year. Nothing. No injury at all.
My, mar, did not find any mark of injury. No injury, my lord.
ওরাল বলছে না, বলছে যে ও বলছে যে পেছনে হচ্ছে
Page 29, there is an error.
না, এখানে এখানে বলছে যে এই জায়গাটা বলছে যে দেখুন এই এখানে বলছে ওর এদিকে ওর এভিডেন্সে বলছে জায়গাটা দিচ্ছে, দেখলাম একটা জায়গায় এই যে দাও বাচ্চাটা বলছে যে এই বাচ্চাটা বলছে yes for sorry, no. The petitioner is the father of the victim girl who was about 6 years at the time of the offense. Full stop. Learned counsel for the petitioner submits that the medical report indicates that the hymen was intact and there was no mark of injury on the body of the child. Full stop. Moreover, comma, a matrimonial dispute is going on between the mother of the child and the petitioner, comma, her father, and the complaint lodged by the mother is a fallout of such dispute. Full stop. In the plaint, in her matrimonial suit, comma, the de facto complainant stroke mother alleged at the same time that since 2015, since the year 2015, comma, the parties have been living separately, whereas the offense was committed on July 17 and July 18, comma, 2021, full stop. The complaint was lodged much thereafter on December 26, 2021, which, according to learned counsel for the petitioner, is also a ground for creating doubt on the allegation. Full stop. The petitioner is in custody for 3 years and 7 months. Full stop. Next para, learned counsel cites judgment of the of a learned single judge of the Kerala High Court in the matter of Aravind versus State of Kerala. Full stop. In the said judgment, comma, the learned single judge considered triple X versus State of Kerala and another bracket 2024 SCC online KER 3595 and triple X versus State of Kerala bracket 2024 KHC online 692 for the proposition that in matrimonial disputes between the husband and wife, comma, the minor children would be meddled and weaponized, MEDDLED, meddled and weaponized to wreak, WREAK, vengeance at the teeth of the POXO Act. Full stop. It was further held that in such cases, the court should be deciding the matter with great caution. Full stop. Next para. Upon learned counsel for the state opposes state as de facto complaint as well as the de facto complainant seriously oppose the prayer for bail and controvert the allegations made by the petitioner. So next para. On a perusal of the divorce petition, matrimonial suit filed by the de facto complainant wife, comma, we find that the statement that the parties have been living separately since the year 2015 is has to be construed in the light of the rest of the statements made in the plaint. Full stop. In paragraph 9 of the plaint, comma, she has stated that they last resided together on February 10, 2015. তারপর double inverted মধ্যে in her matrimonial home, double inverted close, full stop. On the other hand, comma, in paragraph 5, comma, it has been stated that after a few, paragraph 4, it has been stated that after the birth of the daughter, the present petitioner started torturing his wife, and thereafter amicable settlement was held in vain. Full stop. Accordingly, the de facto complainant moved to her mother's house. Full stop. In paragraph 5 of her plaint, comma, it is stated that the respondent within bracket present petitioner bracket closed again came to the house of the petitioner, and they started residing their conjugal right together. A daughter was born, a child was born on March 1, 2022. Full stop. Next para, thus, comma, read as a whole, comma, the plaint case shows that even as per the allegation of the de facto complainant, comma, at the time of the offense, comma, the spouses were living together. Full stop. Thus, comma, nothing in the divorce suit, the matrimonial suit vitiates the prosecution case in any manner. Full stop. Next para. In respect of the injury report, comma, it is trite law that if the victim is a child of tender years, within bracket, in the present case, comma, 6 years, bracket closed, the absence of injury might be the outcome of the failure of the minor to protect herself or even to understand properly the consequence of the offense at the relevant juncture. Full stop. That apart, comma, keeping in mind the relationship between the relation between the petitioner and the victim, within bracket father hyphen daughter bracket closed, comma, it might very well have been that the petitioner was a position to have sufficient sway, the SWAY, on his daughter to commit the offense repeatedly on 2 consecutive days. For sub next para, lastly, comma, the difference of about 5 months in lodging the complaint is completely understandable, comma, keeping in view the fact fact that the matter was inside the family and a lot of shame and trauma might have come in between the discovery of the offense and the lodging of the complaint. Push up next para, in view of the heinous nature of the crime, comma, particularly keeping in mind the relationship between the victim and the father, comma, we find that the alleged mitigating circumstances come to naught, NAUGHT. Push up. Accordingly, CRAN, this is CRAN 1. CRAN 1 of 2025 is dismissed. Sorry. Yes.
My lord, direction of paper book may be given.
The paper book shall be prepared within 4 weeks from the arrival of the records.
Great.
Thank you. Affidavit of service filed today be kept on. Next.
Number 9. Lord, I am for the appellant. Lord, I am praying for next circuit. Lord.
Oh, so heinous.
Not so heinous, Lord. While going through the records, I find something.
On the prayer of the petitioner, the matter is adjourned till the next circuit.
Great.
Millet, in item number 10, Millet, I'm appearing in virtually. Kindly permit me to appear virtually, Millet.
Yes, please.
Millet, I'm renewing my prayer for suspension of sentence. Millet, there are 3 petitioners before your lordship who are Manik Chandra De, Virendra De, and Virendra Chandra De. Millet, the conviction is under section.
I'm interrupting for a moment, my lord. My lord, in his petition, he has not served with us with the copy of the judgment, my lord.
I
I-
have a judgment, my lord.
You have a judgment right now. How can I read the whole judgment and reply, my lord? Next circuit.
Judgment is not mandatory to be given in a bail petition. You are the state. You know ought to know the judgment.
How, my lord?
From the records, you are the state.
No, how can I, my lord? The records are available.
Just as they can.
No, they have obtained certified copies and all. We don't have. My lord.
State cannot have access to the records.
In case of bail, my lord, we have access to CD and other documents. And appeal bill is a different thing, my lord. Unless they give us a copy of the judgment.
Why is it different? The records have not come.
No, it doesn't come to the prosecution office, my lord. If once a record
The
is
prosecution sometimes has to move to the department.
No, my lord, no.
Everything will not come to you.
No, my lord, what is that? What happens in such cases?
You are briefed for the state, Mr. Vishwas. It's your responsibility to go and check up whether the records have come and what is the judgment.
My lord, usual practice is that at least a copy of the judgment is given.
Let's see if they rely on the judgment at all. Yes.
The conviction under section 304, that is the main section where the sentence is given for 10 years. The alleged incident is this, on a day of a
How long
Kali
are you in
Puja.
custody, Mr. Lahiri?
I am in custody for about 6 months post conviction. I was in custody from 7th of February. The alleged incident happened on the day of Kali Puja when these appellants in a group merged into the house of the PW2 where they assaulted the PW2.
Achha, wait a minute, Mr. Lahiri, wait a minute. Mr. We'll take it up, say at 1.
My lord,
Go to the judgment.
10/4/2025, the bill application was received.
In that, if you want to go to the judgment, we can take it up at 1. Give a copy of the judgment to you. We are passing it over till 1, Mr. Lahiri. Please come back online. 1.
I'll read it.
Give a copy of the judgment, please, to him. You are also there. Yes.
I called her yesterday. Informed her that you have not supplied with the copy.
Then you should have given a copy. If she told you why she tried means, you asked for a copy yesterday. This is unfair. At 10:30 at night, you asked for the judgment for?
My chamber starts at
10:30. Ends?
2
Then with such thoroughness, you should have been prepared with the judgment. Anyway.
Sometimes 3 o'clock, my lord, the diabetes is uncontrolled.
Oh, don't do it. Age will catch up sometime. Now you are still young, but
My lord, the problem is
don't do
I
that.
can for 5 hours continuously with a special tool. So I cannot, that 5 hours I need for reading, my lord.
Achha.
That is the reason I keep active service. I can only read 5 hours continuous.
Oh. Sorry, I mean, try to come prepared, Mr. If you're in real trouble, tell us, we'll not take up the matter.
I'll come.
You just try, yes. Yes, next matter, who is? Oh, you're for, achha, you've changed sides. Yes.
Switch
Switch the sides. This is section 6 must be.
Section 6. My lord, it's a very peculiar case. My lord, I was put to trial under section for offences under section 6 of the POCSO Act.
আচ্ছা 1 minute, give us half a minute. আচ্ছা বেল গুলো যতক্ষণ চলবে না তুমি এটা লাইভ স্ট্রিমিংটা বন্ধই রাখো। এই অ্যাপ্লিকেশন ফর বেল গুলো আপ টু 16 পর্যন্ত লাইভ স্ট্রিমিং বন্ধই রাখো।
My lord,
সেকশন 5 আছে?
I just will be saying next. Mr. Hilo Chapoda was supposed to be here, but he was unavailable.
On the prayer of the appellants, the matter is adjourned till the next circuit. Give your name. Not Mr. Shahabuddin's name. Yes, Mr. Ghosh.
On the last occasion, Miller, there was a direction to serve.
Section 5 is there?
Yes.
Service affected or?
Millard, in my last affidavit of service, Millard, That is showing item delivered addressee.
Address C, yes. Then delivered. No, address is sender. It
But
would be
in the column, it is showing Milord Jalpaiguri. That's creating the confusion. Milord
address is at somewhere else.
Darjeeling.
Oh,
Jalapad Darjeeling.
thank you for the fairness.
It's creating Milord
Dipankar.
confusion, Milord. Probably
Yes. Serve again, Mr. Learned, we appreciate the fairness of Learned Counsel for the appellant who points out that although the track report shows that service has been effected on the addressee, comma, the post office indicated is Jalpaiguri, whereas the addressee resides at Darjeeling. Push up, accordingly, comma, it transpires that proper service has not been effected. Push up, the affidavit of service is kept on record. However, the appellant is directed to serve afresh copies of both the applications on the respondent, indicating that the matter shall be listed before the next circuit when an affidavit of service shall be filed by the appellant. Thank you. Serve both copies. You have served already both. Because immediately after section 5, whoever takes up must be taking up the order 41 and taking up the.
Item number 19.
Yes, Mr. Sharkar.
I am looking for the
You vanished yesterday. Yes.
application person.
Your learned junior was in difficulty, but he managed the show. Yes. This is that bad matter which we adjourned. Probably this one. Yes. This is that matter that we heard you. No, this is not matter. That is a single. Please remind me. Yes, what is this matter?
So, in this matter, I am agreed by an order of ad interim injunction which was passed against me in a suit for cancellation of deeds and
What is your ground? And
I am in possession of that land and the order was passed
Oh.
restraining me from entering into the possession. So
Oh.
the execution of sale deed is admitted. Execution is admitted, although they are making a case that they were supposed to execute a mortgage deed in my favor, and I have fraudulently obtained a sale deed. And
Any finding in the impugned order? Let us see regarding this. He being in possession. Let us try to find out.
the impugned order is in page number 25.
We are looking at that. Yes, we are looking at that. In the deed, is it reflected whether it's that there is a an agreement for reciprocal transfer, or it's a mortgage, or it's a security? Nothing of that. Deed is clear cut sale deed.
Deed
Please,
is in page number.
Mr. Shaka, we rely on you. Just check up whether there is any indication that it's a mortgage.
Page number 30 is the deed. Clear sale deed has been executed. Subsequently, they have made out this case.
Has it been mentioned in the deed anything about possession being handed over to you?
Yes, sir.
Let us just show see that portion.
Even the ROR has been prepared in my name.
Oh.
Yes. ROR is in page number 27. 21st November 2024, it was prepared in my name.
Let us see the relevant portion of the sale deed where possession is handed over is mentioned.
Page number 5. Page number 5 of that deed, page number 37 of the CAN application. It is a continuation of page number.
Hereby sold and makeover possession.
Described in the schedule below, and makeover possession thereof to the purchaser together with all rights, interest, liberties, easements, privileges,
এটা স্টে করছি, কারণ এটা না হলে ডিসপোজিস হয়ে যাবে, মানে ঘুরিয়ে ডিসপোজিশনের অর্ডার নিয়ে গেছে।
For the preservation of the suit property, there is something else.
Exactly. You are a good civil lawyer. The learned, no, heard learned counsel for the appellant. Full stop. By the impugned order, comma, an ad interim order of injunction was passed, has been passed in favor of the plaintiff stroke respondent. Full stop. The suit has been filed for cancellation of a deed, of a sale deed, of a registered sale deed executed in favor of the appellant by the respondent. Full stop. The case in the plaint is that the same was meant to be a deed of mortgage, and pursuant to the same, comma, a substantial amount of the consideration was returned by the plaintiff stroke respondent to the defendant stroke appellant. Full stop. Next para. By the impugned order, comma, ad interim order has been granted restraining the defendant stroke appellants from disturbing the peaceful possession of the plaintiff stroke respondent, possession and enjoyment of the plaintiff stroke respondent in respect of the suit property, and not to encroach upon the suit property and stroke or alienate stroke transfer or create any third party interest in respect of the suit property. Push up next para. We find from the sale deed, registered sale deed which has been challenged in the suit, that the same is an outright deed of sale, and there is no whisper whatsoever of it being treated to be a security for a mortgage or any mortgage having been created on the basis of the same. Full stop. Moreover, comma, we find in the impugned order that there is not a single line of recording as to how the plaintiff has as to whether the plaintiff stroke respondent is in possession of the property at all, comma, particularly in the teeth of the clauses of the sale deed, which clearly show that simultaneously with the execution of the deed, comma, possession was handed over to the appellant. Full stop. Learned appellant, the learned counsel for the appellant also relies on extracts of the records of right which have been annexed to the application, which go on to show that the property has been recorded in the name of the appellant pursuant to the registered deed. Full stop. Thus, comma, insofar as the grant of injunction regarding possession and enjoyment of the property allegedly by the plaintiff respondent is concerned, comma, we find that the same, comma, on the basis of the materials and pleadings produced by the plaintiff stroke respondent herself, comma, would tantamount to granting an eviction of the defendant stroke appellants, since the defendant stroke appellants are in possession and injunction has been granting, restraining them from disturbing the alleged possession of the plaintiff stroke respondent. Full stop. However, comma, insofar as the injunction relating to alienation, transfer and creating third party interest is concerned, comma, we find that in the for the ends of justice, comma, such portion of the order does not call for any interference prima facie. The next para, accordingly, a sufficiently strong case for hearing of the appeal on merits has been made out. So accordingly, the appeal is admitted and shall be heard on the above questions and the grounds taken in the memorandum of appeal. Full stop. You have applied for stay.
No, Rashid, no stay has been applied. Can application has been filed for appropriate order only.
You have said to issue a rule calling upon the respondent to show cause as to why it should not be set aside.
Yes.
In injunction, interlocutor stage, we will grant you liberty, amend the prayer portion and the cause title. On the prayer of learned counsel for the defendant stroke appellants, comma, leave is granted to the learned advocate on record for the appellants to carry out the necessary correction to the cause title of the application as well as the prayer portion thereof by incorporating a prayer for stay of operation of the impugned order. Full stop. There shall be stay of operation of the impugned order bearing order number 2 dated April 23, 2025. Passed by the learned civil judge, bracket senior division at Siliguri in title suit number 44 of 2025 to the limited extent insofar as by virtue of the same comma, the defendant stroke appellants have been restrained by an order of injunction from disturbing the peaceful possession and or enjoyment of the plaintiff respondent in respect of the suit property, comma, till disposal of the application. Full stop. However, comma, it is made clear that no stay order shall operate in respect of the other portion of the impugned order, comma, whereby the defendant stroke appellants have been restrained from uh, alienating, transferring and or creating any third party interest in respect of the suit property. Full stop. The appellant shall serve copies of the serve a copy of the application bearing can 1 of 2025 along with a copy of the memorandum of appeal on the respondent indicating that the matter shall be listed before the next circuit subject to being mentioned before the appropriate bench. Full stop. The appellant shall file an affidavit of service to that effect on the next occasion.
Yes.
Thank you. Carry out that correction. Application will be for stay and the other portion, prayer portion.
Here I am the plaintiff appellant.
Right.
Prayer for ad interim injunction has been
Refused. What is the suit for?
This is the suit for declaration, cancellation of deeds, and recovery of possession.
What sort of declaration? Oh, there's a section.
Of my right.
There's a section 5.
No, Lord. It is within limitation. This is a can application for injunction.
Declaration of your title or
Of my right title interest in respect of the suit property.
cancellation of a deed.
Of the deeds.
Deed of sale executed by you.
Lordship, sale agreement and sale deed. I am 80 years old person.
Yes.
And I had a plan to develop a land for housing project. And due to my old age and feeling sick, I was supposed to engage one developer. I engaged the defendant number 1 and 2 as a developer of that land to subdivide the plots of land for the housing project and to sell it to the intending purchaser of developer's allocation. And owner's allocation will remain with me. I will sell it to the intending purchaser.
You are the developer.
No, I was the landowner. I have engaged the developer.
Right.
But subsequently it was found that while the development agreement on different date and the development power of attorney, which was supposed to be executed in his favor, in these two agreements, they have actually, at the time of registration, by way of misrepresentation, they have taken my signature on agreement to sell as well as sell deed. And they did not pay any consideration to me because as per development agreement, which was verbally settled between us, they were supposed to develop the land with their own cost and get the developer's allocation. And I was supposed to get the owner's allocation. And
now, court has disbelieved on the ground that you have been transacting many deeds. You are a businessman and you have not challenged your signature. So the fraud aspect had to be proved even prima facie by you. What is your allegation regarding fraud? How was the fraud committed?
In
particulars under Order 6 Rule 4 have to be there.
Lordship, I have clearly stated in my plaint.
It's a question more than a fraud. It's a question of misrepresentation.
Lordship, misrepresentation. Lordship.
What is your case of misrepresentation? What did they represent to you? What was being done according to them?
They have
you executed a deed, an agreement, knowing fully well that it would be a an agreement for sale.
I have one registered agreement is there, agreement to sell. At that time, it was agreement in 15/2023. At that time, there was discussion between us that I will execute a development agreement in their favor.
No, that agreement also you are challenging.
Lordship, that agreement I have also challenged.
How can you challenge that? You knowingly entered into that agreement. You admit that.
No, I was supposed to enter into development agreement.
And this was made into an agreement for sale.
Sale, Lordship.
But you are an educated person. You sign your name.
No, Lordship, I may be an educator, but I am an old person.
Old person, that does not mean you are a naive
they
person.
provided me a draft copy of the development agreement. I have stated in my plan. They have provided me a draft copy of the development agreement. I have checked it during my journey also. They have provided me in advance. I have checked it also during the journey.
Sir, Sarkar, court has.
But when I arrived at the registration office,
yes.
At that time they have.
But the court
they have
has
taken my signature.
We don't find any fault with the judgment because there is a discussion why it has been refused. Uh, no question of interference here. You fight out the ad interim has been, no, injunction application, ad interim has been refused.
Ad interim has been refused.
No, we'll
property
directly.
has to be preserved. Otherwise, this person will have no place.
No,
Otherwise,
because if
the
they're a
suit-
developer, they'll transfer the property. I mean, we cannot restrain them just on your averment.
They have already created multiple interests, and if they sell out the entire property, then where will I be
ultimately prove করে
at the end of the
তখন
trial?
গিয়ে তো তখনের সত্যি মাল্টিপ্লিসিটি হবে সেটা ঠিক। কিন্তু নিয়ন্ত্রণ না থাকলে যদি বেঁচে যায় তাহলে কিছু প্রবলেম নেই। এখন সেট করা যাবে না, ad interim একটা স্ট্যাটাস কোড দিয়ে তাহলে সার্ভ করতে বলবে। Very well.
So kindly see the impugned order. They have
Businessman, and that you have entered into several documents and you have admitted your signatures, so you have not.
The learned court below merely refused the say the registered instrument carries a presumption. But I have challenged those registered agreements.
Learned counsel for the appellants will granting. Learned counsel for the appellant argues that the learned trial judge erred in law in refusing ad interim injunction. First of the allegation in the suit, comma, the plaintiff appellant has sought for a declaration of his title and cancellation of an agreement for sale and a deed of sale on the premise that those were obtained by misrepresentation, and has also sought for recovery of possession. First up, the case of the appellant is that the appellant was made to understand that he was entering into a development agreement with the respondents developers. First up, however, comma, when the agreement was ultimately entered into, comma, subsequently the plaintiff appellant discovered that it was converted into an agreement for sale as well as a deed of sale. First of next para, learned counsel submits that at this stage, comma, the learned trial judge ought to have considered the plaint case as the premise of the ad interim prayer and not gone into the merits of the case. First of next para, we find from the impugned order that the learned trial judge has, by way of reasons of refusal, comma, stated that once a deed is registered and the executant does not challenge his signature, then it is the duty of the executant to prove that the fraud was played upon him before the execution of the deed by adducing evidence. First of next para, it has been also recorded that the appellant admittedly went through a draft copy as well as final copy of the document and then signed the same. First of next para, however, comma, a basic apparent error in the order is that the appellant does not challenge his signature, but the plaint case revolves around alleged misrepresentation, comma, on the part of the respondents, inasmuch as the appellant was made to understand that he was signing some other agreement than that which has actually been registered. So moreover, comma, the perusal of a draft copy cannot be equated with the perusal of the final copy. So apart from that, comma, the premise on which the learned trial judge proceeded was that fraud has to be proved by adducing evidence, comma, which is a premature consideration at the stage of grant of ad interim injunction. Full stop next para. Moreover, comma, it is well settled that at the stage of consideration of an ad interim prayer for injunction, comma, the plaint and injunction application pleadings are to be treated as sacrosanct, and the limited scope of the court is to consider whether on the basis of such allegations made in oath, comma, the plaintiff has made out a prima facie case for trial. Full stop, applying such tests, comma, it transpires that in the event transfers transfers happen in the meantime, comma, it may create unnecessary multiplicity of proceedings, and it might be difficult to execute the decree, comma, even if the suit is ultimately decreed, comma, against third parties who may be bona fide purchasers for value without notice of the suit. Full stop, in such view of the matter, comma, the appeal is admitted and shall be heard on the above questions, and on the grounds as taken in the memorandum of appeal, there shall be stay the parties shall maintain status quo as regards nature, character, possession, as well as transfer and or alienation and or creation of third party interest in respect of the subject property till disposal of the application. The appellant shall serve copies of the memorandum of appeal as well as the application on the respondents, indicating that the matter shall be listed before the appropriate bench in the next circuit, when an affidavit of service to that effect shall be filed by the appellant.
Great.
Right. মৃণাল কয়েক জায়গায় অ্যাপেলেন্ট হয়ে গেছে, অ্যাপেলেন্টস হবে বোধহয়, একটু দেখে নেবেন আপনি।
Appeal 21 I appeal for the respondent.
For the respondent আছে
And for that.
এটা, কিন্তু এটাতে আদার সাইডও আছে। Section 5, what is the delay?
137, 137 days.
130, what is the explanation?
I have annexed, I have narrated in paragraph number 6 onward.
Tell us.
Also, in the order, the impure order was applied within due time, Lordship, but subsequently what happened, the learned trial court, the conducting advocate has kept with the documents for himself for assessment of the merit to get appeal and all. Subsequently, a conference was held before the concerned advocate for a long period of time, but ultimately the suggestion they have offered, the petitioner was not satisfied. Subsequently, he sought for another assistance from the another advocate, wherein they have wherein the file was kept lying for a considerable period of time. Subsequently, that matter was.
You are the third advocate. You are the third advocate. And what about the tuberculosis business?
That his father, the petitioner's brother, was a acute patient of tuberculosis, for which he has to go.
Yes, Mr. Ghosh, what do you say?
Lord, as regards limitation, that may be.
We'll make it in order of the court.
Yes.
Heard learned counsel on the parties. We find from the pleadings made in the condonation application that sufficient reason for the delay has been made out, in as much as the appellant went to several advocates, several learned advocates for advice, legal advice, and ultimately chose the present advocate. So moreover, comma, in the interregnum, comma, the aged mother and the younger brother, comma, the latter being a patient of acute pulmonary tuberculosis, comma, were under treatment, comma, which the petitioner had to take care of. Push up. Accordingly, can 2 of 2025 is allowed. We are making it on contest, Mr. Ghosh.
Yes.
On contest, thereby condoning the delay and preferring the appeal. What is the appeal about? We are now hearing the
custody battle lordship of a child.
Oh.
The Act 8 application was filed by the mother-in-law lordship.
Mother is not alive.
Mother is not alive. During the course
Lord,
of
he killed the mother. If I may, Lord, on the point of stay, my lord, it needs to be seriously objected.
No, we'll hear you.
Yes.
On the stay, not as a matter of course. You are appearing, we cannot do that.
So after marriage lordship, the couple was leading a happy conjugal life, but one incident.
No, what have you challenged in the appeal?
I challenge this appeal. The impure order of judgment of custody has been custody and guardianship. The mother-in-law has been appointed as a guardian of the child.
Under the Guardians and Wards Act.
Guardians and Wards.
This will be classified as a miscellaneous appeal. No regular first appeal. It has to be formally admitted. No, FMT number has been given.
Yes.
Oh, that has been corrected. Very
Yes, that's correct.
well. Please carry on. Yes. So custody has been given to the
Mother-in-law. Mother-in-law.
your mother-in-law. Yes. The child's
Maternal grand.
Child.
Maternal grand.
Sorry, maternal. Sorry, I stand corrected. Sorry.
mother-in-law of the child and your grandmother.
Sorry.
Your mother. Forget about yourself. The child's maternal grandmother.
Yes, grandma.
Very well. There's an allegation of you killing the mother or something like that.
No, the issue was that during the course of leading of a matrimonial life lordship, there was an accident of suicide by which my wife has committed suicide and he has died, and for which a criminal case has been registered by my mother-in-law, which is trial is pending.
The charge against you is murder or abatement to suicide?
Murder, but
that trial is going on.
Your lordship was
age of the child and gender?
7 years old.
Son?
No, daughter.
Daughter.
Then,
is there any other female member in your family?
No, yes, my mother is there.
Your mother is there.
My mother is.
But you have to take care. The mother is ailing so much, you have to take care all the time. She won't be able to look after the child.
Ailing of
aged mother and brother.
Aged mother and.
What is the age of your mother?
Mother age is 58, I believe.
Only 58. So we should not have allowed the section 5. Aged mother and brother. 58.
So, yeah.
আমাদের বুঝি।
Sorry, sir.
Why was the custody given?
Custody was given. Can you see the impugned order first?
So go shift. Yes, take your seat. We want to ensure that you don't use the microphone during his.
See, the
No, no,
can number 1. Can 1 impugned order.
No, we are looking at the impugned order from the certified copy. You can refer to the internal page. So many judgments. It's an elaborate judgment actually.
Yes. The order portion, can you see?
Oh, the child has been residing with the maternal grandmother since long.
Yes. Since the occurrence, from the date of occurrence.
When was the occurrence?
Occurrence of 2020. And it was on 14th of August. 14th of August 2020.
So was under custody. Father was in custody.
Subsequently, father has been released ordered by.
No, we are not on the custody. No, therefore the child is 7 years old. During 5 years of that growing years, she has been with her grandmother.
Now she is.
We have to admit the appeal because it's put on question of fact and law. We'll formally admit the appeal, but now you are asking for what? Visitation.
Visitation right was given, but it has. I have not been allowed to meet with my child till date on a premise that since she has, she is one of the witness in the trial. She is to attend the trial. Now the fact is this, Lordship, on last our examination, that is my child's
Mr. Shah, it's a bit difficult.
Why I'm telling, Lordship, why I'm telling this, and I'm telling this application, take out this application, because that on 3rd of January 2025, the examination of child has already been completed. Now there is no other apprehension that I may have any fair chance to tutor him or anything else, whatever else.
Examination of the child in the trial.
In the criminal trial that has been done. Now, your Lordship, kindly see at page in the bail order, the prima facie hold. Kindly see at page 146. Annexure P8.
Yes.
It's a case of suicide, and the suicide note was left by the victim wife.
No, this is for the purpose of bail.
No, I am just pointing out that this is a suicide, but since he was, but there was a
bail order is not at all any adjudication at all. Absolutely prima facie. And before this bench, the presumption is that we were extra liberal. So therefore, we do not rely on that at all for this purpose.
What was the pinching?
This bench's order, bail, no.
Sorry.
No benefit from them.
Since the examination has already been completed of the child, so there is no immediate apprehension to get tutored by me or anything. So now my humble submission is this: by virtue of the
Subject to hearing them, we have not yet heard them. We'll hear them definitely right now.
Yes.
But at best, we can think about giving you a limited visitation right. Suppose once a month or something like that at the home of the maternal grandmother. At best.
So that order has already been passed, I believe, but not in.
In the impugned order itself, that is there.
See, in the impugned operative portion, order portion. The petitioner is appointed the guardian of the person and property of the minor child.
Ordering portion.
Order portion.
Shipra Shah, yes, yes, that we have seen.
Yes.
Where is that visitation right?
Visitation right was
No, second paragraph
Second
of that
paragraph.
page. Page 19 of the judgment. No, second paragraph from the top. Internal page 19 of the judgment.
Before the ordering portion.
Yes,
Achha.
before the ordering.
Page 19, internal page 19. Directed to accommodate the opposite party father to visit the house of the petitioner for a purpose of meeting the minor child and playing with her, and to provide all the facilities.
This is more than what we were thinking. We are thinking of a limited visitation right once a month, and this is blanket. I mean,
this order has not been carried out because the mother-in-law.
Yes, Mr. Ghosh, what do you say if you formalize it by way of a, suppose once a month, particular day of the month, second Saturday or something like that, and the hours will also fix,
Yes.
so that it's not vague. We can understand your apprehension also, because if it's vague, anytime he can go and play.
Yes.
So,
At present, my lord, the safety of the child is of paramount importance because
true.
she has stood by her version because she happens to be the sole eyewitness
No, but
of the incident.
we are not saying that he would do anything, but even then, the evidence of the child is already over.
Yes.
So therefore, she, even if she is now, I mean, sought to be influenced by him. First of all, he is with you, she is with you. So there's little chance of in a visitation. How can he do that? And moreover, obviously, she has given evidence. She is also not a suckling baby. So 7-year-old is has intelligent preference. Now 10 years, so she's sufficiently mature to handle that. So we'll put it on once a month. What day suits you, the child? Any Sunday or
Sunday would be good.
Sunday would be good.
Fortnightly can it be? Can it be fortnightly?
That's a fortnightly will be.
Yes.
Fortnightly will be. Very well. Fortnightly, Mr. Shaha, what would be a suitable time to put? We'll give 2 hours.
Yes.
Every alternative Sunday. That means every alternative Sunday, fortnight. What hours would suit the child? We are bothered about that.
My lord, preferably in the morning.
Morning, Sunday morning.
11 to
11 to 1. Perfectly fine. We'll do that.
Any in the my mother-in-law's house or any other independent place?
Not in the mother-in-law's.
Mother-in-law.
That
For the timing, Mr. Shah, let us gain some confidence on you. Mother-in-law's house.
So this is the common factor lawsuit apart from this lawsuit because my
No, we'll say, Mr. Shah.
Execution is can't be possible in this way.
No.
The similar problem I am facing that despite the order, I am not been allowed to meet with my daughter.
No, you can ask for implementation by making an application. Execution, obviously, by police will not do that.
Certainly.
But then we can think about appointing a special officer.
Yes.
We can do that right now. Name a special officer. You can be the special officer. Go there and remain for those 2 hours. Any lady who is a bit junior but does not, we don't want to say that not too busy.
But special officer at this stage would not be required if I may candidly submit. My lord. Let the order be.
Mr. Ghosh, your client may disturb be in the middle of of his client and the child.
Certainly, my lord.
Throughout the.
If he has an apprehension, that has to be respected. My lord.
His right to have the visitation there must be some privacy. He'll be in a room in that same house. She may be in the next room, but not with them. That won't be a visitation.
Then in the presence of a special officer.
That is what we were thinking. Name a special officer, both of you. Any lady, the remuneration will be paid by you.
Mrs. Chakraborty.
She's too busy for this. Much more. She won't be able to handle it. She's too junior.
Any new member of.
No, the difficulty is all of you are busy. That is the day. Then we can think about Miss Chakraborty. Yes, if she's agreeable. Yes, she's saying yes, you're saying. You have some difficulty. She may be prejudiced by the Mr. Ghosh. Very good. The present admit kore oitai kore dicchi. The present appeal in the present appeal, questions of both fact and law are involved. So accordingly, FMAT 19 of 2025 is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. Can 1 of 2020, we are disposing of the application. We will give both of you liberty to approach the court if there is any difficulty in this visitation. Can 1 of 2025 is an application seeking custody and or visitation. Full stop. Next para. The basic facts of the case are that that a criminal case is at present going on against the appellant on the charge of murder of his wife, right? Wife. Full stop. The present custody dispute relates to a 10-year-old daughter of the appellant. Full stop. By the impugned order, the learned trial judge has given custody of the child to the respondent, who is the maternal grandmother of the girl. Yes. Full stop. Next para. Learned counsel for the appellant submits that despite a provision of visitation of the child having been made in the impugned order, comma, the same is not being honored by the respondent. So next para, learned counsel for the respondent's contents that the child of the appellant is a key witness to the murder, and as such, comma, her safety as well as the probability of being influenced by the appellant cannot be ruled out. Full stop. It is further submitted that the respondent apprehends the security about the security of the child being jeopardized if a prolonged visitation is given to the appellant. Full stop. Uh, it is submitted that since the paramount consideration in custody matters is the welfare of the child, comma, keeping that in view, comma, the prayers made herein ought not to be granted. Full stop. Learned counsel for the petitioner contends that the evidence, the deposition of the child is already over in connection with the criminal case, and as such, in any event, comma, there cannot be any apprehension. So, moreover, comma, the appellant denies having any role to play in the alleged offense and assures the court that he will not influence the child in any manner. Full stop. Upon considering the rival contentions of the parties, comma, we are of the opinion that uh, as a father, comma, a limited visitation right, comma, the parameters of which should be fixed, comma, may be granted to the appellant. So, moreover, comma, even in the impugned order, comma, an opportunity was given to the father to be accommodated if he wanted to meet and play with his child. Whose next para, accordingly, can 1 of 2025 is disposed of by granting visitation rights of the minor daughter of the appellant to the appellant uh, every alternate Sunday between 11 a.m. and 1 p.m. Full stop. The first such meeting will be on from this Sunday onwards, August 3, 2025. Full stop. Next para. Keeping in view the welfare of the child and the apprehensions of the respondent, comma, as well as the acrimony between the parties, comma, such visitation right shall be held in the presence of a learned special officer. Push up. Accordingly, we appoint Ms. Maton Chakravarti, Ms. Maton Chakravarti, comma, a learned advocate of this court, as the special officer who shall remain present during the visitation hours and shall supervise the visitation. Full stop. During the period of visitation, comma, which will be held at the house of the respondent where the child is residing now, comma, the respondent and or her family members shall not interfere with the visitation right in any manner. Full stop. However, comma, the special officer shall be at liberty to take decisions without interfering with the uh, privacy of the visitation between the father and the daughter. Full stop. You may be there, Ms. Chakravarti. It's your discretion. We have left it to your discretion. Full stop. Next para. The remuneration of Ms. Chakravarti, comma, learned special officer for each of the visitations is hereby fixed at what will be a reasonable.
That is up to the.
Ms. Chakravarti will go out of the court so that they can say. No, what should be a reasonable? Let her not say that. What's your fee for an appearance? What is your fee for an appearance, Mrs. Jha? What should be commensurate? She's no, more than that. Those days are gone. What do you do for a profession?
School teacher.
School teacher. What is your salary?
Salary is 820.
No, 3,000 out of question. 10,000 না কম হয়ে যাবে না 2 ঘন্টা থাকবে ওখানে এখানে ফি স্ট্রাকচার যথেষ্ট ভালো এখানে ফি স্ট্রাকচার কলকাতার চেয়ে ভালো হয় স্যার বাজে কথা বলে লাভ নেই তো একটা সানডে স্যাক্রিফাইস করবো 20,000 Mr. Participant.
20,000.
Yes.
That will be too high. So that
20,000.
my salary is.
What is your salary? Mr. Chakravarti, you take your seat. You have been appointed to take your seat. You are not involved in this. What is your salary?
233 page. 233.
What is the monthly salary?
70,000.
66.
66,000 per month. Then we'll get 10,000. At rupees 10,000 per visitation. Full stop. The remuneration for each occasion shall be paid at the time of visitation by the appellant to the learned special officer on each such occasion. Full stop. This arrangement shall continue till disposal of the appeal. Full stop. However, liberty is granted to both parties as well as the learned special officer to mention the matter before the court in the event any difficulty is faced by any of the parties or the learned special officer in such visitation rights taking place. The appellant shall, in view of the appearance of the respondent through her learned advocate, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing for enlistment before the appropriate bench as and when the same is ready for hearing. Thank you. Thanks. একটা সময়টা ডাব একটা সময়টা বেল আচ্ছা বিশ্বরূপ আবার লাইভ স্ট্রিমিংটা অফ করো Yes, you are for the petitioner.
Kindly to come to the last paragraph. The paragraph starts with Shanti Rani De.
Yes,
kindly see. Yes, kindly see the second last sentence of that paragraph. Ratan assaulted with volume on the head of the Topon Pal. Topon Pal is the deceased village. And he immediately became senseless and fell on ground.
You are Manik.
I am Manik, Biren, and Hiren, and Hirendro. Manik, Birendro, and Hirendro are before your lordships. My lordship would kindly enough to come to inner page 21 and 22 of the judgment. First, my lordship would kindly come to page 21. In fact, while the learned judge was convicting the accused persons under section 304, not under section 302, this learned judge was also of the opinion that this presence of the deceased at the place of occurrence was uncertain, and there was no premeditation or any decision to murder the deceased. And as such, the intention to murder the deceased could not be inferred. And as such, the conviction was given under section 304 itself. Now, it's a case of term imprisonment. Your lordship knows that when there is no mandatory life imprisonment, the consideration for the suspension of sentence in case of the term imprisonment is liberal than the mandatory life imprisonment. And when this nature of the injury, this single blow incident, the uncertainty of the presence of the deceased at the place of occurrence, everything has been corroborated by the medical evidence also. And this
uncertainty of the presence of the disease is not doubtful. It is clear that disease was not the primary target of the accused persons.
He suddenly came at the place of occurrence to mitigate the situation.
Whatever, but that does not determine the offense. I mean, he might have come, but
he might have come, but
understood. I had not premeditated, targeted. He being targeted. So he was not
being targeted. It was not target at all, and that there was a single blow, maybe on the vital part of the body, but it was a single blow. The single blow itself indicates that they don't have the sufficient knowledge and intention to commit the murder of the deceased. And secondly, so far as the merits of the case is concerned, if your lordship sees the seizure itself, your lordship will find that on 28th of October, this is an incident of 26th of October.
You say that you are not involved because the single blow was dealt with by Ratan.
By Ratan, that is the evidence of PW2 who happens to be an injured eyewitness.
So you are not an accomplice as such also to that 304 from that 304 angle, because you might have come for an altercation with Bollum, etc.
Maximum subjective correction there can be a liability under section 34 since I was present over there. So considering this entire circumstances and considering the period I have already suffered the custody.
Period is nothing. 6 months is.
My lord, kindly consider it's a case of term imprisonment. My lord, kindly consider. My lord, I'll be relying upon one decision of the Honorable Supreme Court. Ms. Isha Acharya will hand over to your lordship, my lord, of 1999. Your lordship knows that that was also a case of 392, and where the imprisonment was granted for 10 years. The Honorable Supreme Court released him on bail because of the term imprisonment. My
And
lord.
you had bail during the trial also.
Yes, yes. Throughout the trial, I was on bail. My lord.
Yes, let us see the judgment since you are citing.
But it's a short judgment, my lord. If your lordship kindly consider paragraph 2 and 3.
Yes, that is the test. Para 3 is the test.
The 3 is the test. My lord.
When a convicted person is sentenced to a fixed period of sentence and when he files an appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. Of course, if there is any statutory restriction, it's the other way around. So, as a matter of right, almost he's entered to bail very liberally unless there is some exceptional circumstance.
Exception is there, I mean, injured witness cannot be impeached.
Heard learned counsel for the petitioner, footstep, learned counsel for the state seriously opposes the prayer for bail. Footstep next para. From the circumstance, learned counsel for the petitioner cites such and such reported 1999 4 SCC 421 for the proposition that in case where there is a fixed period of sentence and where an appeal is a statutory right, suspension of sentence can be considered by the appellate court liberally, unless there are exceptional circumstances, barring statutory restrictions against suspension of sentence. So next para. In the present case, the sentence awarded is of 10 years. The offense alleged was under section 304 of the Indian Penal Code. By taking us through the materials considered by the learned trial judge, learned counsel for the petitioner has convinced us that one Ratan, along with whom the present petitioner and other present petitioners were also there, had dealt the fatal blow on the victim, which ultimately resulted in the death of the victim. Insofar as the present petitioners are concerned, it has rightly been contended that at best they could come within the purview of section 34 of the Indian Penal Code in terms of the prosecution evidence as well. Keeping in view the said circumstances and the fact that the petitioners never jumped bail during trial, when they had been enlarged on bail, as well as borrowing the principle from Bhagwan Rama Shinde's case, Supra, we are of the opinion that since a fixed sentence is has been awarded and the appeal is a statutory right, the suspension of sentence can be the prayer for suspension of sentence should be considered liberally. Full stop. Next para, accordingly, grant 2 of 2025 is allowed, thereby granting bail to the petitioners on condition that each of the petitioners shall furnish bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local. The sureties can be common for all the petitioners. Next para, the petitioners shall, to the satisfaction of which court? Which
My
court?
lord, to the satisfaction of the CJM, my lord, Kuch Bihar.
To the satisfaction of the learned CJM, Kuch Bihar, the petitioner shall not, during the pendency of the appeal, intimidate or induce the witnesses in any manner and or tamper with the evidence and shall not leave the territorial jurisdiction of the local police station. Whose sub next para, the petitioners shall make themselves available as and when so called upon to do by this court during the pendency of the appeal.
Extremely grateful, my lord.
No, first sentence is that. First sentence. We don't take a risk now. First sentence, we start with that. Strongly opposes the prayer, and then we start.
Extremely grateful.
Affidavit service file to be kept.
কিছু হয়নি বলছিলাম দাদা, কালকে বলেছিলাম না তোমার ওই 3টে 3:30 নাগাদ যাবো।
কাল তো কোর্ট।
হ্যাঁ, তো আমি বলছিলাম যে বইটা নেক্সট উইক একদিন সমস্যা একবার ফোন করি।
এসো, নেক্সট উইক আমি খুব চাপে থাকবো।
তাহলে নেক্সট উইকে কবে, শেষের দিকে,
শুক্রবারের দিকে করো।
ফ্রাইডে, তাহলে
হ্যাঁ,
আমি ফোন করে নেবো।
না
কোথায় মেনশনিং ডাকো লিস্ট ডাকো
It's a second appeal, my lord.
What is the delay, Mr. Ghosh?
28 days.
Explanation.
Many legal layers, my lord, coordination and my lord coming
Yes.
together and preferring, my lord.
We are recording your opposition.
Vehement objection. I mean, there's a substitution application also.
Oh, within time,
Within time.
after filing of the appeal, right?
Yes, it's after filing.
Acha. Just check up, Mr. Ghosh.
Uh,
13th May. Yes, right. During pendency of the appeal. The CAN 3 of 2025 is an application for substitution of the heirs and legal representatives of the deceased respondent number 2, Sri Paresh Kundu, who passed away on May 13, 2025. Full stop. Since the application is in time and otherwise in form, Mr. Ghosh, you have not stated major and sui juris. We are recording that. Yeah, acha, since the application কেটে দাও তার বদলে লিখো learned counsel for both sides submit that all such heirs are major and sui juris. Full stop. As such, since the application is in time, CAN 3 of 2025 is allowed, thereby directing the substitution of the names of the heirs and legal representatives of the deceased respondent number 2 as the particulars of whom has been mentioned in paragraph number 3 of the application, as respondents in place and state of the said deceased in the appeal. Full stop. The necessary consequential amendments to the memorandum of the appeal shall be carried out by the learned advocate in record for the appellant during the course of the day. The years. CAN 1 of 2025 is an application for condonation of the delay of about 28 days in preparing the appeal. Full stop. Upon hearing learned counsel for the parties, I find that sufficient explanation for the delay has been given due to lack of coordination between the heirs of the original parties. Full stop. Accordingly, CAN 1 of 2025 is allowed, thereby condoning the delay in preferring SAT 5 of 2025. Full stop. The appeal be listed before the appropriate division bench in the next circuit for hearing under order of Rule 11 of the Code of Civil Procedure. Thank you.
Number 2.
Yes, Mr. Majumdar.
Lordship.
Yes.
In this revision, the mute question that crops up before the Honorable Court is, if a defendant is injuncted, does that mean that he cannot drink water?
What does it? You put it in a very interesting way.
Lordship, the suit property was a
Yes.
vacant land in the year 1963. In 1964, petitioner's father entered into an agreement of tenancy of the land. And the same year, he built a semi-permanent structure, wooden and half wooden.
Entered into tenancy means you got the landlord or your petitioner?
Petitioner's father was a tenant.
Achha, he entered into that. Yes. Built a structure.
Built a structure and he was running a hotel by the name of Ashoka Hotel since 1964.
It was a vacant land when you took.
Vacant land.
Then it should be a ticket tenancy.
But at that time, Thika tenancy was not applicable over here.
Right. 60s.
And still now it is not applicable over here.
Oh, achha.
So, my lord, in somewhere in the year late 80s, early 90s, there was an agreement between the landlord and the tenant for sale of the demised property. That did not take place. Petitioner's father departed, and his widowed wife brought out and sued for specific performance of contract, which was, however, it did not materialize, it got dismissed. But since the date of tenancy agreement, my lord, the petitioner's father stopped paying rents.
Somewhere in the year 1995, the landlord's successors, they tried to disturb the tenancy. Proceedings were brought out before the rent controller. There, the landlord's successor went and said that petitioner's father was an illegal occupier. But he continued till the night of Saraswati Puja 2023, when a fire broke out and the hotel was substantially damaged. When he tried to repair, a suit was brought by the landlord's successors for injunction. Surprisingly, my lord, I don't want to delve in the title suit very much. They said we do not suffer any special damage, yet the court granted injunction. But since the injunction was only on the construction, not on the business, running of business, defendant was not that way injured. Defendant appeared, filed a written statement, and obviously, my lord, a counterclaim will come in for declaration of title by way of adverse possession.
Why adverse possession? You were a tenant.
No, I
It's a contradictory.
No, my lord. I rejected my thesis in the year 1995 when he told me that I was an illegal occupier. My landlord tells me I am an illegal occupier.
But you admit that then if you claim adverse possession.
I did not pay any single rupee rent to him.
But tenancy automatically does not go. Tenancy would have been a better plea anyway. So adverse possession.
That the trial court will look into.
All right then.
Now, there was a demolition order passed by the corporation under the prompting of these plaintiffs. That was challenged before the Honorable High Court. Honorable High Court asked the corporation to find out whether there was any building plans. Without doing that exercise, they can pass a demolition order. Again, it was challenged, it was stayed. At this interim, the petitioner found that the water source that was there, my lord can appreciate, when a hotel was running, there was a water source. It needed repairs. And the drain in front of the hotel premises, it got locked due to waste accumulation.
The hotel is still running in whatever remains.
Still, in the whatever remains are there, they are running a tea shop now. What was a full blast hotel is now running a tea shop. Now, an application was filed before the trial court asking the court to grant permission to repair the water sources, to access water, drinking water, and to allow the defendant to unclog the drain.
Injunction was in respect of what?
Building. My lord, even if I repair the water resources with my own resources, my own costs, still it will be somewhat construction.
So you prefer
I prayed for an permission. The opposite parties entered their objection. They said that we have suppressed the writ proceedings. My lord, the writ proceedings had nothing to do with the title suit. And if they rely on the writ proceedings,
they may say that the demolition order is there. It doesn't state.
They themselves say that the Honorable Justice Amirudda Rai has passed an order not to take any coercive step. In spite of that, the trial court said, since there is a demolition order, you go and seek permission from the corporation for water and unclogging of drain. My lord, I do not need any.
Otherwise, in law, you do not need any such permission from the corporation.
No, water source is always there.
What is your exact prayer? You want to unclog the drain?
Unclog the drain
and
so that sewerage is working and drinking water that pipeline got damaged. I want that pipeline to be repaired of my own cost. Now, my petition was rejected only on the one ground, suppression of fact, with 6,000 rupees cost.
Against that you are coming up?
Yes, sir.
What did you say?
My lord, the petitioner is the running hotel in the said premises. Since long, that is true, my lord. That is, my lord, asked.
You're trying to oust them in a oblique fashion, My
lord, the wooden structure. On 17/2/2023, the said wooden structure burned into ashes, my lord. And my lord, a massive fire broke down, which causes, my lord, the death of one person. Thereafter, my lord, the respondent here, being the plaintiff, filed one title suit for restraining the petitioners to, my lord, not to construct anything without the proper permission from the SMC, that is the Siliguri Municipal Corporation, as well as, my lord, the West Bengal Fire Department, upon which injunction has been given on.
They are still in possession, and this is not construction.
They are not in possession, my lord.
Possession, when did possession go?
My lord, the case is that the entire building has been turned into ashes. and there is an
Even in the
injunction,
possession
and
remains.
my lord, thereafter, with violation of the injunction order, my lord, they constructed a tin shaded structure.
No, whether
Let-
the
let
injunction
me-
order was later on passed.
tin shaded structure, upon which, my lord, the one Krishna Devi, co-sharer of the property, make one application before the Siliguri Municipal Corporation, and upon which, my lord, the Siliguri Municipal Corporation direct them to demolish the shade structure. My lord, the entire building was turned into ashes. There is a no question of repair of the drainage system.
That demolition has been stayed by the writ court.
My lord, yes, my lord.
No court order.
No, my lord, no coercive, as well as there is a direction to demolish the structure of the petitioner.
No,
There is a standing demolition order.
No,
as
that
well as
standing
the-
demolition or no coercive action has been passed by the
No,
High
we have
Court.
a demolition order.
High Court did not pass a non-coercive order.
Objection to the trial.
The demolition order has been
It's
not,
still in exist, my lord.
but that has been no coercive action has been
As
directed on
because
that.
there is a direction to file affidavit in opposition.
No
Until
coercive
then,
action is an interim relief.
but until then, there is a no coercive action, my lord.
Yes.
There is a direction of affidavit in opposition.
Where is that order or the admission of that?
My lord, page 65.
My lord, there is an injunction order. How can they, my lord, change the nature and character of the said property, my lord? Kindly see.
No, let Mr. Pal help him. What is it?
So he is the last descendant of Pal kings, and he always fires from the back. And by the way, he is also a contemporary.
Kings have a habit of doing that.
My lord, these two are contemporaries, my lord. Three coordinate benches directed to give the birthday party treat. They did not till date.
Mr. Dhor arranged for the party, but himself consumed whatever were there.
Mr. Pal?
He's an accomplice. Lesser.
Page 58, there
My
are
lord,
151 applications.
65, my lord. Being agreed by the order dated 6/1/2025, the defendants filed a writ petition being
No coercive.
WPA.
Yes, Mr. Modi.
So, my lord, injunction order, I have admitted that on the construction order,
No,
I cannot
let
construct.
him complete that. You just take your seat, yes, Mr.
My lord,
Modi.
page 58, my lord. There are 151 applications.
Yes.
My lord, point 9.
No seat behind you. Missing arrange.
That the existing water connection needs to be
Yes.
repaired in the said premises most urgently. My lord, when the entire building was turned into ashes, my lord, there is a no question of existing water connection. If there is a question of existing water connection, that means, my lord, they have been built a unauthorized construction without, my lord, violating the injunction order of the learned trial court. And my lord, there is a injunction order that if you construct anything, you can construct with the prior permission of the Siliguri Municipal Corporation as well as the fire department, my lord. And my lord, learned trial court rejected their application rightly. And my lord pointed out that you have approached the proper forum. If you want to construct, you can approach the Siliguri Municipal Corporation as well as the fire department, then you construct. And there is a standing demolition order, my lord.
No, we'll set aside this.
My lord, kindly see the injunction order.
My lord, I have annexed it.
My lord, they are saying that water connection, my lord, it is not the residential home.
It is a utopia to run a hotel without.
Mr. Mujumdar, I'll direct, I'll set aside the order, but I'll direct a prior local inspection to ascertain whether there is any water connection.
My lord, there is a well there from there. My lord,
Whatever way, water connection is there or not. Because the premises existing water connection will be repaired.
Yes, ma'am.
We won't permit any new construction.
No, we will not.
So we'll
But
just
once
ask.
if you are desirous of having a local inspection, let it be done. But by whom, my lord?
Court will appoint, trial court will appoint. Learned advocate, any learned advocate. We'll do that. We'll dispose of the revisional application. The premise of the revisional application is short, comma, but the antecedent, history is a bit checkered. Full stop. According to the petitioner, comma, there was an agreement. According to the petitioner, comma, the predecessor interest of the petitioners was a tenant in respect of the suit property under the predecessor interest of the opposite parties. Full stop. Subsequently, however, the property was gutted by a fire. Full stop. Thereafter, comma, the petitioners took a stand that they were in adverse possession of the property. Full stop. A suit was filed by the present suit was filed by the plaintiff stroke opposite parties for declaration
Only injunction.
for permanent injunction restraining the petitioners from making any construction over the suit property
Without permission of them.
without permission of the
Siliguri Municipal West Bengal Fire Department.
Siliguri Municipal Corporation and the West Bengal Fire Department. Fire Safety Department. West Bengal Fire Safety Department. Thank you. Fire Safety Department. Push up next para. In such suit, an interim order of injunction was obtained to such effect. First up, the learned trial judge restrained the defendants to petitioners from making any sort of construction over the suit premises without obtaining prior permission from the Siliguri Municipal Corporation or the West Bengal Fire Safety Department as on that date till disposal of the suit. Push up in the suit, the petitioners have also filed a counterclaim. Your counterclaim is for a declaration of a title on the basis of adverse possession. And any consequential relief, any injunction, no. Counterclaim.
Injunction is running on the suit property.
Counterclaim, claiming title on the strength of adverse possession. Push up in the said suit, the petitioners took out an application under section 151 of the Code of Civil Procedure, seeking permission to take necessary steps to unclog the drain and repair the existing water connection in the suit premises. Full stop. Next para. Learned senior counsel appearing for the petitioner's contents that whatever remains of the suit premises is being utilized for running a small tea stall by the petitioners, and as such, water is an essential commodity. Full stop. Since there was an existing connection all along, and the petitioner's possession of the property has not been disputed as such, it is contended that the learned trial judge acted without jurisdiction in refusing such prayer merely on the ground of suppression of the fact that there is an existing demolition order from the Siliguri Municipal Corporation. For sub next para, however, it is submitted by the petitioners that the said demolition order was subject to challenge before before this court. For sub in connection with the said writ petition, an interim order was passed to the effect that no coercive action shall be taken on the basis of the demolition order. For sub next para, as such, the suppression, the non-disclosure of such fact, was not germane. For sub next para, learned counsel for the opposite parties opposes the prayer made in the revisional application and submits that after the premises were gutted by fire, nothing remains on the same, and if a water connection is sought to be made now, it will tantamount to a new construction. Full stop. It is submitted that it will be a contradiction in terms if a premises which is under injunction from making further construction, in the garb of taking water, repairing water connection, a fresh construction would be built. For sub next para, learned counsel further submits that the demolition order still subsists and was a germane consideration. For sub the suppression of the said fact in the before the learned trial judge by the petitioners tantamounted to a suppression of material fact, and the learned trial judge was justified in refusing the order permission paid for by the petitioners, since there is already an existing demolition order. Full stop. Next para. Upon considering the submissions of the parties, it transpires that the injunction which has been passed in the suit restrains the defendants stroke petitioners only from making within double inverted any sorts of construction, double inverted clause, over the suit premises without prior permission from the Siliguri Municipal Corporation or the West Bengal Fire Safety Department. However, the fact that the petitioners have all along been possession of the property, in whatever capacity, has not been disputed as such. Next para, it is well settled that till a person is evicted by due process of law, the said person, the occupier, has every right to amenities to the property. Next para, the question which arises is whether in view of the demolition order, comma, the petitioners were entitled to get such order of repair of the water connection and unclogging the drainage system. Push up next para. Mere existence of a demolition order does not obviate the fact that the petitioners are still in possession of the property. Pushed up in fact, comma, the demolition order itself indicates that there is an existing structure, comma, of whatever nature, comma, be it a tin shed structure or otherwise, comma, on the property. Full stop. In view of the non-coercion order passed by the writ court, comma, it cannot be said that the demolition order has been set aside, but in the same breath, comma, it cannot also be said that the same is operative at the present moment. Full stop. Next para. Till the petitioners are, comma, if at all, comma, evicted by due process of law, comma, the petitioners have every right to enjoy minimum amenities to the premises. Full stop. Of course, comma, whatever order is passed by this court, comma, would be subject to the outcome of the writ petition challenging the demolition order and the decision in the civil suit. Full stop. Be that as it may, comma, as on date, comma, as well as on the date when the impugned order was passed, comma, there was an order of this court restraining coercive action on the basis of the demolition order. Full stop. Hence, comma, I do not find that there would be any material alteration of the property in the event the the repair works and unclogging of the drain in respect of the existing water connection is undertaken. Full stop. However, comma, in order to ascertain whether there is at all any existing water connection, comma, which is required to be repaired, and a drainage system which requires unclogging, comma, a local inspection would be necessary to be held. Full stop. In view of the above considerations, comma, CO 90 of 2025 is allowed, comma, thereby modifying the by setting aside the impugned order and directing the learned trial judge to appoint uh, an advocate commissioner for the purpose of holding local inspection to ascertain whether there is any existing water connection at the suit premises, and, comma, if so, comma, the nature of repair required thereto. Full stop. The said learned commissioner shall also ascertain as to whether there is an existing drainage system in the property, and if so, comma, whether the same requires unclogging. Full stop. For such limited purpose, comma, the learned trial judge shall appoint an advocate commissioner at the earliest at the cost of the petitioners. Full stop. Next para. Upon such inspection being held and a report being filed, comma, the learned trial judge shall ascertain the contents of the same, and if it is found that there is an existing water connection and a drainage system which is clogged, comma, the application for permission to repair the existing water connection and unclogging the drain shall be allowed. Full stop. Next para. In the event, comma, however, comma, the commissioner's report indicates that there is no existing water connection or drainage system at all in the premises, comma, such prayer shall be refused. Full stop. Next para. The entire exercise, comma, keeping in view the urgency, comma, shall expectedly be concluded within 2 months from the date of communication of this order to the learned trial judge. For sub next para, it is made clear that nothing in this order shall create any special right or equity in favor of either of the parties and shall not prejudice the outcome either of the pending suit or the pending writ petition and or any proceeding if going on or undertaken before any statutory authority. Full stop. No arrest to cause urgent certificate. Thank you.
Lordship needs the date of the impugned order.
Oh,
13th.
right. No, I have it. যেখানটা বললাম না যে the impugned order is modified. Thank you, Mr. Mujib. Impugned order is modified. একটা বললাম যেখানে CO number such and such is allowed thereby setting aside বলেছি। the impugned order bearing order number 14 dated March 13, 2025, passed by the learned civil judge, junior division at Siliguri, district Darjeeling, in title suit number 65 of 2023. Thank you.
Great.
এটা ওর মধ্যে ঢুকে যাবে। Yes. No caveat?
No, Lordship.
Very good. What is the matter?
Yes, that is matter, Lordship.
Yes. Yes, oh, this is the matter. Yes. Just remind me what is the matter about?
Lordship,
You make your argument in your own way, yes. But your Mr. Shah must be given credit. He hold the fort very well. Yes. Yes, what is
the
it?
impugned order is in the certificate copy, Lordship. My shoot was for partition and injunction. And defendant number 1 and 2 are the co-sharer of the Schedule A property, and the defendant number 3 and 4 are the contiguous landowner. And here the misunderstanding cropped up. The defendant number 3 and 4 has also been described as a co-sharer.
You have described in your plan.
Lordship. And the defendant number 3 and 4 property has been described in a different schedule. So actually, probably the plaintiff could not express their case properly. Actually, they have tried to made out their case that defendant number 3 and 4 in collusion with the defendant number 1 and 2 are creating construction involving some portion of the shoot property. That was their main case. That is why defendant number 3 and 4 has been added as a party. They are the contiguous landowner. That is why the Schedule B property has been mentioned in the plain as the defendant number 3 and 4's property with a specific boundary and with demarcation. And defendant number 3 and 4 being agreed by the ad interim injunction passed in favor of the plaintiff in the partition suit.
But in a plaintiff have stated that you and the plaintiff defendant numbers 1 and 2 are the co-sharer.
Co-sharer. And defendant number 3
But no, yes, are also co-sharer.
They should have been described as contiguous.
Unless there is an amendment, then they...
And kindly see the Schedule B of that plane.
Seen.
Different schedule has been given.
Your paragraph 3 is demolishes your case.
Lordship,
Everything else is what you are saying. Everything else is what you are saying. No, what was the impugned order? Just show us the impugned order.
In the certificate copy, Lordship. Defendant number 3 and 4 preferred this miscellaneous appeal against the ad interim injunction, stating that there is no unity of possession between the plaintiff and the defendant number 3 and 4. It is almost evident from the plain and from a different schedule.
Ad interim was granted or injunction?
Ad interim was granted. And from that ad interim, defendant number 3 and 4 preferred appeal, stating that there is no unity of possession or unity of share.
What sort of injunction was granted ad interim? What is the injunction? Restraining whom from doing what?
Not to change the certain character of the property, not to...
Against all the defendants?
Against all the defendants. Since the defendant number 3 or 4 are in collusion with the defendant number 1 and 2. 1 and 2 are the co-sharer from common descendant, ancestor.
But then is a partition suit maintainable? Partition suit, they need to be bad for misjoinder of parties and misjoinder of cause of action also. Two separate sorts of cause of action have been clubbed together.
Lordship.
Partition suit, all the parties have to be co-owners in a partition suit.
But defendant number 3 and 4 actually constructing in the defendant number, stating that it is defendant number 1 and 2's share.
But the suit is bad for misjoinder of causes of action then. Because in the same suit you can club outsiders even if they disturb you.
That is curable.
How will you cure it?
If I abandon one portion of the claim, the suit may be cured.
If you abandon, then how can you get an injunction against 3 and 4?
Defendant number 3 and 4 are involved in the
partition suit does not lie. Don't find any irregularity in the order. I'll record your submissions and Mr. Sarkar, I'll give the plaintiffs liberty to take out an amendment if that and to renew your prayer if such amendment is allowed.
And time boundly the injunction application.
You have not yet filed that application. If time bound, if I make it time bound, the same pleading will remain. Then you will again, the injunction application now will be rejected. Learned counsel for the petitioner contents. The present revisional application arises against an order whereby the learned first appellate court allowed the miscellaneous appeal filed by defendant numbers 3 and 4 in a partition suit. Push up, the plaintiff stroke petitioner filed the partition suit on the averment that the plaintiff is a co-sharer of the property with defendant numbers 1 and 2, and that defendant numbers 3 and 4 are colluding with the defendant numbers 1 and 2, thereby disturbing the possession of the plaintiff in respect of the suit property. Push up, learned counsel for the petitioner submits, submits that inadvertently, the defendant numbers 3 and 4 were also described in paragraph number 3 of the plaint as co-sharers, whereas they are third parties and adjacent owners of the suit property. Full stop. The cause of action against the defendant numbers 3 is segregable as against defendant numbers 1 and 2, since the partition has been sought primarily against the co-sharer stroke defendant numbers 1 and 2, whereas other reliefs of injunction and declaration have been sought in view of the defendant numbers 3 and 4 disturbing the plaintiff's ownership rights in respect of the property. Full stop. Next para. Whereas the learned trial judge granted an ad interim injunction in favor of the petitioner, the appellate court reversed the same primarily on the observation that the parties to the suit are not co-sharers, since the defendant numbers 3 and 4 claim on the basis of separately demarcated deeds as opposed to the defendant numbers 1 and 2. Push up next para. It is contended that in view of the fact that the defendant numbers 3 and 4 were impleaded in the suit not as co-sharers, but since they were disturbing the possession and enjoyment of the suit property by the plaintiff, the premise on which the appellate court proceeded was without jurisdiction. Push up next para. However, on a plain reading of the plaint, it is evident that in paragraph number 3 thereof, the plaintiff has described the defendant numbers 3 and 4 as co-owners as well. Full stop. Moreover, a question would arise as to whether the suit for partition would be maintainable in its present form and not be bad for misjoinder of parties stroke misjoinder of causes of action, since it is doubtful as to whether third parties apart from the co-owners of the property can be impleaded in a partition suit. Full stop. Next para. Apparently, the causes of action, in terms of submission made by learned counsel for the plaintiff stroke petitioner, in respect of the defendant numbers 1 and 2 is different from that against the respondent numbers, defendant numbers 3 and 4. Full stop. Be that as it may, as the plaint stands as of today, I do not find any jurisdictional error or irregularity in the order of the first appellate court, which allowed the misappeal on the premise that all the parties are not co-sharers to the suit and the issue of maintainability of the suit is hit. Push up next para. However, I make it clear that nothing in this order shall prevent the plaintiff stroke petitioner from having his plaint amended and or relinquishing a part of the prayers and stroke or segregating the causes of action against the parties either by way of amendment to the plaint or otherwise. Full stop. In the event such amendment is applied for and allowed by the learned trial judge, the plaintiff stroke petitioner will be at liberty to file a fresh injunction application. Full stop. Accordingly, CO 100 of 2025 is dismissed, thereby affirming the impugned judgment and order dated March 6, 2025, passed by the learned additional district judge, second court at Alipurduar in miscellaneous appeal number 18 of 2024, in the light of the observations and liberties mentioned above. No arrest to cost. Urgent certificate.
There was no prayer for declaration. It was declared that declaration was also paid.
Declaration বলেছি Declaration of your one-third share has been made. In the plain, oh no. যদি ডিক্লারেশন কথাটা কোথাও পাও তো তাহলে দিয়ে দিই বা বোল্ড করে রাখো, আমি করে দেবো। থ্যাংক ইউ।
Number 4. Time for the
Yes.
Yes. Asked to produce.
Original plain language. What is the matter about? Just rewind once. Sorry.
This is regarding this
Amendment.
that they wanted to change the date of cause of action.
Amendment has been allowed.
It has been allowed. Order is based in.
Amendment, proposed amendment is at page?
Page 14 of my.
Page 14.
Mention the page number.
Watch.
Sorry.
No, the amendment application is there. Where is that?
After the certified copy.
Oh, acha. After certificate.
Second page of certificate. Third page of the certificate. Flag this copy of the plain for your convenience.
This only say this notice dated to 8/2022. The date on which you received the notice. That does not change the cause of action. The date of notice remains the same.
They have said that they were
5/9/2022. In paragraph number 9, they say they have given a notice dated to 8/2022, which you received on 5/9/2022. Date of receipt is sought to be changed. Date of notice, if that was sought to be changed, then
but para 10 million.
para 10 is
Cause
first
of
day of
action.
November. Yes. Cause of action for the suit arose on first day of November, they have stated.
But they wanted to change this 1st of October.
This was under which act? Transfer Property Act or Premises Tenancy?
Rejectment suit.
Under which act? Premises Tenancy Act is applicable here.
Yes.
This is the Premises Tenancy Act area. If the date of the notice is the cause of action, under section 6, notice is the cause of action. The date of notice remains the same. Therefore, the cause of action remains the same. I mean, 1st October, 1st November, how does it make a major difference? And trial has not yet started. It's a pre-trial amendment.
Yes, hearing stays.
When the amendment was filed, it was not then.
It was not there.
At that point of time, it was.
We hesitated, but the trial judge was not convinced with your submission there.
No, on the date when the amendment application was filed, the trial had not started.
Because
you had filed written statement.
Frame the issues thereafter.
That is not. Issues had been framed then.
Yes. Thereafter, they came for the amendment.
The notice mentions which date as the date of your till after.
Notice was
When do you have to leave?
August second, my lord.
No, in the notice, what has been? Yes, let us see. The notice mentioned it correctly. They only in the plain they say the notice remains that this is not a major change. No interference.
But they are changing the cause of date of cause of action. Date also as
No,
month
the
also.
notice is the cause of a basis of the cause of action. No,
Month also, my lord.
only the month, not the learned. The present challenge has been preferred against an order whereby an amendment to the plaint in an eviction suit under the West Bengal Premises Tenancy Act 1997 has been allowed. Push up. Learned counsel appearing for the uh, defendant stroke petitioner contends that by virtue of the amendment, comma, the entire nature and character of the suit has been sought to be altered. Pushed up. The crucial basis of the suit, comma, that is the date of the cause of action, comma, has also been sought to be changed by the amendment, comma, which is not permissible in law. Push up. Learned counsel for the petitioner argues that by the impugned amendment, comma, the cause of action of the suit, which was originally mentioned in the plaint to be November 1, 2022, has been changed, has been attempted to be changed to October 1, 2022, comma, which takes away the very premise on which the suit was filed. Full stop. Next para. However, comma, on a perusal of the proposed amendment, comma, I find that the basis of the suit, eviction suit, was the notice dated August 2, 2022, which has been referred to in the plaint and remains unaltered even after the proposed amendment. Push up. The cause of action in a suit under the 1997 Act is the notice of eviction under section 6 within bracket 4 of the said act. Pushed up. In the present case, comma, the proposed amendment does not seek to alter the factum of the notice or its date. Pushed up. In the notice itself, comma, the date from which the defendants were directed to vacate the premises was October 1, 2022, which have since the notice itself or its date has not been denied, comma, but it was a mere typographical error in the original plaint that the cause of action of the suit arose on November 1, 2022, whereas the notice itself states it to be October 1, 2022, comma, the plaintiff have only sought to incorporate what is there already in the pleadings and the notice, which is an integral part of the pleading and referred to in the plaint. Pushed up. The other component of the amendment is the date of receipt of such notice by the defendant, comma, which is entirely immaterial insofar as the cause of action of an eviction suit is concerned. Full stop. Next para. The thus, comma, I find that the amendments sought to be incorporated are minor in nature and formal in character and does not in any manner change the very nature or character of the suit, comma, since the cause of action of the suit primarily is the notice dated August 2, 2022, the date of which or the factum of which has not been sought to be altered by the amendment. Which of next para. In any event, comma, the amendment was taken out, amendment application was taken out at a stage when the trial had not yet begun, and as such, pre-trial amendments do not attract the proviso to Order 6, Rule 17 of the Code of Civil Procedure or its rigors. Push up. Accordingly, I do not find any jurisdictional error or illegality in the order of the learned trial judge. Hence, CO 102 of 2025 is dismissed, is rejected, comma, thereby affirming order number 36 dated April 28, 2025, passed by the learned civil judge senior division at Darjeeling in OC ejectment case number 15 of 2020 ejectment suit, OC bracket ejectment bracket plus suit number 15 of 2022. No arrest to cause sergeant certificate. Thank you.
I for the petitioner also.
First time?
First time.
No caveat, obviously. No caveat. Yes. What is the matter?
So the petitioner praying for transfer of the matrimonial suit from the learned additional district judge.
His divorce suit.
Divorce. The suit has been instituted by the petitioner herself.
Oh, your own suit.
Lords.
Why do you want to transfer it?
Lords, at the time of institution of the suit, the petitioner's father's residence was at the Tufanganj, but nowadays she's residing at Kuchbihar district as because of her child's treatment as well as the schooling of his upper child. And the residence of the opposite party is at Moinaguri, which is Moinaguri and Tufanganj. The Kuchbihar Code is in between the Moinaguri and Tufanganj district. Tufanganj Code.
Which is in between? Kuchbihar?
Kuchbihar is in between the Moinaguri and the, I think opposite party appears, they will not have any objection. I have effected service.
Serve a copy and come.
I'm served.
Was there a direction? Without direction, service has no effect. Because you see that the service is affected nowadays by registered post on our direction. The rule still remains the appellate side rules that it has to be by virtue of a rule through court. We have substituted that just to ensure that quick service is effective. But unless a rule is issued, service has no value in the eye of law. Because there cannot be a rule unless we issue a rule. This is the substitute of a rule. If they appear, both sides appear, and then we say that both sides appear, all right. But if they don't appear, that service cannot be taken note of by the court. This is the principle. I'll give a direction, I'll grant a stay. Your own suit.
Stay order because the
I'll grant a stay of the hearing of the suit so that your interim alimony or whatever other applications are not. That will help you. The present petitioner, the present application under section 24 of the Code of Civil Procedure has been filed for transfer of a suit filed by the petitioner wife herself in the court of the learned additional district judge at Tufanganj, district Kuchbihar, to the court of the learned district judge Kuchbihar. Full stop, next para. Learned counsel for the petitioner contends that although initially the suit was filed in Tufanganj, the father of the petitioner, with whom the petitioner is living, has been transferred since to Kuchbihar. And what other ground you said?
She's her child's treatment.
What is the age of the child?
2 years.
Moreover, the child of minor son or daughter.
Minor treatment as well as schooling of her child.
Minor daughter of the petitioner is merely 2 years old, and for schooling, for admission of the child to the school, which is impending, as well as her treatment, unless the suit is shifted to the court of the district judge at Kuchbihar, the petitioner would have extreme problems to attend the court at Tufanganj. For sub next para, it is further submitted that the husband that the court of the district judge that the district court at Kuchbihar is situated somewhere in between Tufanganj and the residence of the husband at Moinaguri. Full stop. Since a prima facie case for transfer has been made out, the petitioner shall serve a copy of the application on the respondent, on the opposite party husband, indicating that the matter shall be listed before the appropriate bench in the next circuit, subject to being mentioned by the parties. Full stop. There shall be a stay of hearing of matrimonial suit number 50 of 2024, pending before the learned additional district judge, Tufanganj, district Kuchbihar, till disposal of the application. Full stop. It is made clear that the stay order shall not operate in respect of interim applications, if any, filed by any of the parties, and the learned trial judge shall be at liberty to dispose of such interlocutory applications, but not take up the hearing of the suit finally.
Good.
Did I direct you to soft copy? Soft copy বললাম? Soft copy দিয়ে শুরু করেছি? Thank you.
Lordship,
yes.
direction was given to us to serve copy.
What about that?
Lordship, I have served, but I did not receive yet, Lordship.
Learned counsel for the petitioner submits that despite attempt to serve, no service has yet been effected. Full stop. Next para. Accordingly, let the matter stand adjourned till the next circuit.
I'm praying for next circuit.
No.
On the ground of learned senior counsel, Mr. Nimesh Mishra. His mother is admitted in the hospital. Just now.
Learned counsel for the petitioners.
Lordship, I beg to appear for the respondent financial institution in this matter, Lordship.
Petitioner's advocate's mother in hospital.
Yes, yes, he has asked for time for Nimesh, mother, Lordship. There cannot be anything, Lordship. Certainly, I cannot say a thing about that.
Very well. Learned counsel for, and an adjournment is sought on the ground of personal difficulty of learned counsel for the petitioners, who serve learned counsel for the which opposite party? Both.
Lordship, financial institution, Lordship. I don't know, the copy hasn't been served upon me yet. A direction may be given to serve me the copy.
Learned counsel for the opposite party number 1, having instruction to appear for the opposite party number 1 in his usual graciousness, comma, does not oppose such prayer. Full stop. Accordingly, let the matter stand adjourned till the next circuit. Full stop. The petitioner shall effect service of copies of the revisional application on the opposite parties and file an affidavit of service in the meantime.
Grateful, my lord. Much obliged, my lord.
Thank you. Please give your particulars to your learned friends or Mr. Mishra. So
we know each other, my lord. I know. Suman Shah is advocate on record, my lord. We have a chat today in High Court here itself today.
Suman Shah is smiling shyly.
Yes, my lord.
Give a copy to. Yes.
Grateful, my lord.
Thank
you. Lordship, in this revisional application, the original case has been already disposed by
So infractuous.
Yes.
Infractuous. This challenge is against what? What order?
Lordship, in this case, Lordship, section 24 of CPC has been filed before the district judge to transfer the.
That was dismissed, against that you have come up.
Yes.
Now the suit itself has been disposed of.
Yes.
Learned counsel for the petitioner submits that the suit from which the learned counsel for the petitioner submits that the revisional application was preferred against the dismissal of an application filed by the petitioner company under section 24 of the Code of Civil Procedure for transfer of a suit. Full stop. Next para. Since the main suit has been disposed of in the meantime, comma, the present revisional application has also been rendered infructuous. Full stop. On the basis of such prayer, comma, CO 123 of 2025 and the connected Can 1 of 2025 are dismissed as infructuous without any orders to cost. Thank you.
Grateful.
Thank you.
Plaintiff petition.
Yes.
Well, this is against an order of rejection of my application under order of the basis rule 9, my lord.
Why rejected? What is the suit for?
Initial suit.
You are the plaintiff.
Recovery of possession, my lord.
You are the plaintiff.
I am the plaintiff.
Recovered
portion.
portion.
I am the owner of 1.6.
No, recovered portion under which act? Premises tenancy or what?
On the transfer of property.
Transfer property. You say that he is a trespasser or a licensee?
He is a trespasser.
Acha.
I am the owner of 1.65 acres of land, my lord.
Right.
He has occupied 0.05 acres.
All right.
On the basis of a cooperative deed of sale, my lord, executed by one vendor, Upendamani Pradhan, my lord. And the possession has been given within my land. Earlier, I had made.
So you want a measurement of that comparative measurement?
Earlier, application was made, my lord. That was before the trial started. Evidence started, my lord. My lord, kindly come to page 32.
So you have an allegation of encroachment also?
Yes, ma'am. Page 32, my lord, kindly see. This is the first application.
32.
The learned trial court was of the view, my lord. Since the suit is at the stage of threshold, the application
premature to allow.
Was given to me, my lord.
Yes.
But after the completion or deposition of the plaintiff number 1, my lord, I renewed my prayer, my lord, filing another application.
Why rejected?
Granted, my lord.
Why rejected?
My lord, rejected, my lord, saying it can be decided on the basis of.
Submits that the petitioners have filed a suit for recovery of possession on the allegation that the defendants are encroaching upon a portion of the petitioner's plaintiff's petitioner's property. Full stop. Next para. In such suit, comma, initially an application under Order 26 Rule 9 for local investigation was filed, which was rejected at that stage as premature, granting leave to the petitioners to file a similar application later. Full stop. Subsequently, comma, when a similar application was filed to ascertain the extent of encroachment, comma, the same was refused again, primarily on the premise that the suit can be adjudicated without such local investigation on the basis of the evidence already on record, and that the same would tantamount to fishing out of evidence. Full stop. However, comma, a prima facie case has been made out for hearing of the revisional application on merits, comma, since in a suit of such nature where encroachment of a portion of the plaintiff's property has been alleged by the plaintiffs and contested by the defendants, comma, the exact extent of such encroachment is required, comma, a local investigation is apparently the best piece of evidence that the parties can have and would assist the court in coming to a proper and just conclusion. Full stop. Thus, comma, prima facie the learned trial judge acted illegally and with material irregularity in the exercise of his jurisdiction in refusing such prayer. Accordingly, CO 120, the petitioner shall serve copies of CO 124 of 2025 on the opposite parties, indicating that the revisional application shall be listed for hearing before the appropriate bench in the next circuit, subject to being mentioned by the parties. Push up, the petitioner shall file an affidavit of service on the returnable date. There shall be stay of all further proceedings in OC suit number 06 of 2021 pending in the court of the learned civil judge, senior division at Kalimpong till disposal of the revision letter.
I'm good.
Thank you. Your junior was prompting you to ask for that. Stay. Experience. That's why you did not ask. Yes. Next.
আমি পিটিশনের নাম্বার 1 এর ওয়াইফ বলছি।
Oh.
আমি পিটিশনের নাম্বার 1 এর ওয়াইফ বলছি। পিটিশনারের শরীর অসুস্থ থাকার জন্য এটা নেক্সট সার্কিট করবে আবেদন করতে।
আচ্ছা ঠিক আছে করে দিচ্ছি। Is they enjoying interim order?
But I have instructed to appear Miller, but I have not received the brief from that.
Very good.
It is also a party, Mr. Bormon is hospitalized. So
Oh, what happened to Mr. Bormon?
Yesterday, while going down the stairs, he just.
Mr. Hirok Bormon?
Hirok Bormon. In courtroom number 3, he fainted with sweating and little bit of cramps and all. Although there is no stroke, the doctor.
That is what I say. Very well. The আপনি কি পিটিশনার? আপনিও কি পিটিশনার? দুজন পিটিশনার তো।
পিটিশনার নাম্বার 1 এর ওয়াইফ 2 এর মা।
Mother of petitioner number
2.
আচ্ছা there. আপনার নামটা কি একটু বলবেন?
পাপিয়া বণিক।
পাপিয়া বণিক।
বণিক।
হ্যাঁ, Ms. Papia Bonik, comma, the wife of the petitioner number 1 and the mother of the petitioner number 2 appears virtually and submits that the petitioner number 1, who has been moving the matter in person, comma, is in some difficulty. Accordingly, on her prayer, comma, let the matter stand over till the next circuit. Thank you.
Reverend Millard, I beg to appear for the petitioner Millard. It's appearing for the first time. Millard, before Millard takes up the brief, Millard, it's a petitioner is a tea company. Now, Millard, the earlier management abandoned the garden in 2008. 2018-19, a new management comes in place. They takes over the company. By that time, due to default committed by the earlier management, Millard, surface actions were taken out. Sale was published, e-auction conducted, there was no purchaser, the auction failed. In 2020, by way of a all India scheme, the bank granted me a one-time settlement scheme. Now, subsequent to granting of the scheme, we were negotiating with the further terms and conditions with the bank because there are some other issues involved. In the meantime, one third party, all of a sudden prefers a repetition before the honorable single bench, saying that I am ready to pay. The OTS was of 2.36 CR. He offered, I am ready to pay 5 crores. Kindly grant me the property. The honorable single judge dismissed the petition outrightly, saying that you have no longer standing. It travelled up before the division bench. The honorable division bench somehow granted an interim order. Then the matter.
Interim order 2.
Interim order restraining the bank from going ahead with the OTS with me. Now let it travel before the Honorable Supreme Court. Honorable Supreme Court outrightly said it is between the borrower and the bank. He has no local standing. Subsequently, when the matter was transferred from the principal bench to the circuit bench, that appeal before the division bench, it was dismissed with costs. Subsequently, cost was although there is a now this continued.
Position remains that OTS is going on. Now.
OTS is going.
Reverts back there.
Reverse back. 2023, after this all these litigations ended, we started negotiating with the bank that kindly grant us, renew the settlement, these communications, all written, I'll place when, as and when required. All of these negotiations were going on. Then our first offer, once this everything was over, we said that after COVID, financially we are stressed. Our offer is 1.50 CR. The bank subsequently, by way of a communication, which we are looking at as a counter offer, bank says you have to enhance it to 2.36. That was, according to us, that was a counter offer. Once that was
Your offer was how much?
1.50. The bank said you have to enhance it to 2.36 as per discussions held with the general manager. This, that 2.36, it has to be enhanced. We accepted that. In 2024, pursuant to that acceptance,
You are speaking in crores of
2 point, yes.
I suppose, yes. No, obviously it's in courts, tea garden and all. And Mr. Dhod is also there. Yeah.
Similarly,
yes.
once that part was over, the bank said that you submit the signed compromise letter along with disclosing the source of funds. Now, when we
I'm waiting for you to come to the surfacey portion of it. There's no surface. Achha.
Now, simultaneously, when
Yes.
all these things were going on, bank has also accepted payments in lieu of the settlement offer which was going on, and they accepted it as one-time payment in visa.
You paid 2.36.
No.
Installments were agreed according to
Installments. Millard knows that when a one-time settlement or a compromise settlement is offered, they'll always ask for an upfront payment.
Yes.
Which we are treating as a consideration amount. A counter offer accompanied by a consideration amount. Now, once this everything happens, when we write to them that this is the final compromise, as you have asked us to enhance it, we are ready to enhance. This is our final letter. And the source
Now,
of funds was
upfront,
also-
when did the consensus item happen? 2.36, according to you.
2.36 was.
They said you agreed.
We offered 1.50.
They said 2.36. You agreed to 2.36. There, it was a concluded contract.
There it was a concluded contract.
So after that, any upfront payment was made?
Yes.
Oh.
Once simultaneously, when the entire proposals were going on, simultaneously.
That was before the conclusive agreement on 2.36. That was in terms of 1.5, you had made an upfront.
Yes. Even after 1.50 was written to them, they have accepted payments. Millard would find not in one tranche, several tranches they have.
Even after 2.36, they have received something.
Not explicitly.
Not accepted.
Not explicitly, but from the communication, Millard would find it was a concluded contract. There was a consensus item that 2.36 is the final offer.
But then,
now, when everything happens,
yes,
all of a sudden, banks come up with a letter saying that in 2023, in 2025, they are saying in 2023, we have obtained an ex parte order from the DRT against you for an amount of 5 point some crores, which was there since 2023. The order of the DRT.
5 point?
5 point, say 5 crores. I'll place the exact figure.
Yes. Then?
Along with interest. That was there in 2023, the order passed by the
Understood.
DRT. And all these communications happened in the end of 2020. Now, when all these things happened, all of a sudden they say that since there is an order of DRT, we cannot go ahead. Now, prior to this, we had preferred a writ petition before the Honorable Court, saying that, see, everything is concluded, bank has agreed to this, kindly ask the pass a writ against the bank, concluding the one-time settlement, the necessary paper formalities which were laid. In that writ petition, when it was taken up, then bank appeared and said that, no, we have issued a communication saying that this is the letter, we are saying that there is an order of the DRT, we are not going ahead with this. Now, once
that is the first time you came to know about this.
Yes, that was the first time.
In the writ court.
In the writ court. That they have not going ahead with it. Now, once that letter was disclosed, I had no other option but to approach the learned civil court, saying, praying for an injunction against that.
Civil court, how can you? If you want to know.
No, because Millard, it was a communication, there were factual disputes, whether it tantamounted to a concluded contract.
All these points could be taken under section 17.
Probably, Millard, that is one recourse. That is one.
Now
recourse.
that is the law, Mr.
But
Ghosh.
Millard,
Section 17 is all complete, almost.
Millard, now kindly consider this, that the surfacey action which the bank has initiated earlier, that has already culminated into a
You can prefer a challenge before the appellate tribunal.
Millard, we could not, because when the surfacey action proceeded,
Now with section 5 you can. That is your remedy, Mr. Ghosh.
no action under the Surface Act.
Civil court has refused injunction.
Civil court has refused. Millard, in my appeal before the learned district judge, the learned district judge has also refused the injunction.
The injunction application has been dismissed,
No, the ad interim prayer has been rejected.
saying that you have a recourse in the.
No, not on that ground. Both the learned courts below held
There's an
that-
order of the
No,
tribunal.
the courts proceeded on the basis of those line of judgments which says that OTS is not a matter of right. I have no quarrel with that proposition. OTS is not a
No,
matter of
here you say OTS culminated in a contract between you.
culminated into a contract.
But
That was-
also on the ground of maintainability.
Probably not Millard, because Millard would also recall those line of judgments where so far as OTS is concerned.
No, not
one
OTS,
is
not
in
OTS.
The jurisdiction.
No, OTS you can, but here.
But OTS and surface action, Millard, are essentially two different things. Because had I challenged a 13-2 notice, a 13-4 notice, an action taken.
What is the relief in the suit? Let us see.
Yes, Millard kindly takes my plaint once. Millard, it starts at page 26. The prayers Millard would find at Millard page 38.
Yes.
A decree for declaration that the one-time settlement offer agreed and settled.
You settled the plaint.
In fact, I drafted Millard. Kindly.
No. This is the only relief you could claim actually to avoid the tribunal. So what is the rejection order?
No, because none of the reliefs I prayed, Millard, subject to correction, Millard, has any manner.
That is why I said this is the only way you could draft the plaint. That's why that was a compliment, not a. Yes. What is the rejection? Let us see. Let us see the last quote.
Yes. So far as Millard, the trial court's rejection is concerned, Millard, the trial court completely went in a different trajectory. I'll just place Millard the trial court's Millard takes the certificate copy. The last but one page of the trial court.
Yes, I am there.
Yes, Millard, the
Second
second
paragraph.
Document has been placed before me on perusal of the same. It appears firstly, from the various averments in the plaintiff has alleged that the bank has misplaced its original deed affecting the market value of the property. This is neither here nor there. However, from the order in the writ application before the Honorable High Court, Calcutta, it appears that it has been submitted that the said document was misplaced from the custody of the DRT and not the bank, which is evident from the orders of the DRT. Because, Millard, in the writ petition, simultaneously, we also made a second prayer that since you have misplaced the original deeds, I am entitled to compensation. That apart, the second averments made in the plaint is the acceptance, non-acceptance of the OTS amount. But from the communication made by the bank to the plaintiff, it appears that they had rejected the amount offered by the plaintiff, quoting that it is much less than the decreed by the DRT in its judgment and decree, and which was further subject to an interest on so and so. As such,
So
the case
your case is that after a concluded contract, you cannot resile and revert back to your decree.
Correct.
Not a decree. DRT is awarded.
DRT is awarded. Now, since DRT's award was there since 2023.
Therefore, subsequent contract, if entered into between you, waives that.
Waives that. And Millard, there is not one, several communications where the bank has confirmed with me that you have to enhance this and we are granting this. I will show your lordship the relevant communications. Now, Millard kindly takes the order passed by the landed district judge in appeal.
Yes. Very long order.
Very long order.
Both of you are responsible. You must have cited too many judgments.
I only cited the judgments showing that once OTS has been granted or a compromise settlement has entered into, arbitrarily the bank cannot retract.
No, there is no question of further negotiation. OTS cannot be implemented. I mean, you must enter into an OTS. We cannot do that.
Yes.
But here you go one step ahead.
Absolutely. Millard would find that's why Millard.
In fact, your declaration, that's why I saw whether you mention a concluded contract. Those two terms.
Yes.
Those are there.
Yes. Millard kindly takes Millard internal page 15.
Para 26.
Last para 26. Considering the totality of the matter and having regard to the respective submission of the parties and in the facts and circumstances as delineated here and above, I am convinced to hold that there is nothing on record to grant stay or not to give any effect or further effect qua later dated so and so issued by the defense, since in a commercial transaction, a court cannot protect a defaulter at the cost of public money. Moreover, there is no concluding contract in the form of one-time settlement, and as such, OTS has never been accepted by the defendant bank, and no court of law can direct the commercial bank to compromise its financial liability and borrower cannot be encouraged by granting injunction in the appeal once the same has been refused by the Learned Trial Court. Therefore, this is not a fit case in absence of strong prima facie
Mr.
case.
Ghosh, just show me the last, their
Yes.
acceptance of that.
Yes, the most clinching document. which
Yes,
is using
yes,
it, right?
yes.
So the best document.
Where it was, the
Yes.
consensus ad idem was reached.
Yes, Milord.
Page 153, what is this?
Milord, kindly take Milord. I'll show Milord from the annexures of my injunction application probably.
153 is their letter where they.
Yes, the same set of documents, Milord. I'll just show from the annexures.
Different.
Of the injunction. Milord, text page 80, Milord 80 first. 79 rather, 79. 4th September 2024. In the meeting dated so-and-so held with you in presence of our then guardian, GM Sri Mukul so-and-so, an amount of rupees so-and-so was finalized as compromise settlement amount. In view of the above, we are unable to accept your offer of 1.5 lakhs. You are hereby advised to increase your offer amount so that the dues against so-and-so can be settled. This is the bank's communication, September 4. Now, Milord, kindly text page 80. Once again, they reiterate. We have submitted your OTS offer letter of 1.50 crore to your high officers for consideration, but sorry to inform you that it was turned down and advised to increase the offer amount to 226 lakhs. Accordingly, we have informed you via our mail dated so-and-so for increasing compromise offer amount to 226 lakhs. We have not received revised offer till date. Meanwhile, our head officers have in view of the request to submit the same at the earliest. Pursuant to this, Milord would find at page 81 is my response dated 13th November, wherein the third paragraph, considering the above aspect and in anticipation of having a cordial relationship with the esteemed bank, we revise our one-time settlement offer to Swans. 82, Milord would find.
I've gone up to 84, please place 84.
Yes. Yes.
In between, I've seen.
Yes. 84, Milord, it says that Milord would find from a holistic consideration of this, Milord, they have, you are in receipt of your revised compromise offer letter, by which you have revised your compromise offer amount from 150 to 2.26. Now they come to the question of, Milord, the misplacement of the deed. They say that they will hand me over a copy of the FIR so that I can obtain a certified copy. That's what it says. So, Milord, this read in conjunction with the earlier communications, Milord would find that there was a consensus error.
What is the injunction you have sought?
Milord, I have only prayed, Milord, that the letter be, Milord, kept on hold for the time being, and they don't, Milord.
Which letter?
Milord, I'll just come to that. Milord, the last communication which they should do. Milord, the last communication dated 11th April 2025.
Give me the page number.
Yes. That's, Milord, at page 93.
You have not paid for an injunction so that they cannot deal with the property.
I have prayed for.
That is what I'm asking. What injunction
I have prayed for. Milord,
otherwise,
kindly,
this
Milord, kindly takes my prayer, Milord. Milord, from the plaint, Milord.
Plaint, yes, same.
Plaint 39.
Oh, achha.
Schedule to the plaint.
4 and 5.
Yes, 4 and 5.
The present challenge has been preferred against the refusal of ad interim. Ad interim injunction by the courts below. Push up. The brief facts in a nutshell as submitted by Learned Counsel for the petitioner is that the petitioner number 1 is a tea company, whereas petitioner number 2 is one of the directors of the company. Full stop. Initially, during a previous management, loan taken by the bank, loan taken by the tea company from the opposite party bank, opposite party number 1 bank, could not be repaid. Full stop. Subsequently, however, uh, after the new management came, comma, there were talks of settlement between the bank and the petitioner, full stop. The talks of settlement, comma, according to the petitioners, comma, uh, talks of such one-time settlement, OTS capital, bracket OTS, culminated in a conclusive concluded contract between the parties, inasmuch as both the bank and the petitioners agreed to a consolidated repayment of rupees 2.26 crore in full and final settlement of the bank's claim. Full stop. Even after such conclusive agreement, comma, which pursuant to which the talks were going on till the year 2025, comma, all on a sudden, comma, in connection with a writ petition filed by the petitioners seeking implementation of the one-time settlement with the bank, comma, the opposite party number one bank disclosed a purported award passed by the Debts Recovery Tribunal against the petitioner number one company at the behest of the bank. Full stop. The bank thereafter, comma, resiled from its original stand, comma, despite a concluded contract, comma, by issuing a letter dated April 11, 2025, whereby they insisted upon payment of the amount so awarded by the Debts Recovery Tribunal, comma, in complete violation and contravention of the concluded contract already entered into between the parties. Full stop. This, comma, according to the petitioners, comma, prompted the petitioners to file the present suit from which the division arises. Full stop. In the said suit, comma, a decree of declaration that the one-time settlement, OTS capital is optional, offer agreed and settled in between the plaintiff company and the defendant bank for an amount of rupees 2.26 crore has attained finality, comma, resulting into a concluded contract, comma, for a further declaration that the one-time settlement offer of rupees 2.26 crore is liable to be accepted and acted upon by the defendant bank without any deviation therefrom, and for ancillary consequential injunction. Full stop. Next para, in connection with the said suit, comma, an application for interim and ad interim injunction was filed, restraining the bank from giving an effect to the communication dated April 11, 2025, and or dealing with the mortgage property as described in Schedule A to the plaint, and or from changing the nature, character, and position of the same till the disposal of the application. Full stop. In connection, the such ad interim prayer was refused by both the courts below, comma, against which the present challenge has been preferred. Full stop. Upon a thorough perusal of the materials annexed to the present application, comma, it transpires that the form in which the suit has been framed and the reliefs have been sought cannot be granted by the Debts Recovery Tribunal within the contemplation of either the recovery of banks
Recovery of debts and
Dates
bankruptcy.
and Bankruptcy Act 1993 and or the Surface Act 2002. Full stop. Next para, that apart, comma, the courts below, comma, prima facie, comma, proceeded on a fundamentally erroneous premise that the plaintiffs are seeking to implement an OTS, whereas the plaint case and declaration sought is that uh, an OTS already culminated into a concluded contract and seeking to implement such concluded contract, comma, which is in the nature of a specific performance of such concluded contract and ancillary reliefs. Full stop. Next para, from the materials, from the documents annexed to the injunction application before the court below, comma, which are before the trial court, comma, which are also a part of the present records, comma, it transpires that after several communication, comma, a prima facie case of a concluded contract having entered into between the opposite party number one bank and the petitioner number one company, agreeing to settle the debts of the petitioner number one to the bank at rupees 2.26 crore has been made out. Full stop. Next para, thus, comma, the arguable issue which is raised is whether the opposite party number one bank could turn the clock back and revert back to a prior award, comma, despite a subsequent concluded contract which prima facie waives the right of the bank to implement the prior award. Full stop, next para. As such, comma, since a strong prima facie case has been made out, comma, the divisional application is required to be heard on such issue. So accordingly, the petitioner shall serve copies of CO number 139 of 2025 on the opposite parties, indicating that the opposite party, that the revisional application shall be listed before the appropriate bench in the next circuit, subject to being mentioned by the parties. Full stop, next para. The petitioners shall file an affidavit of service on the returnable date. Full stop. There shall be stay of, you have paid for a stay of the suit here.
Yes, Milord.
I'll grant that. See your interim prayer, page 24. Also, a stay of operation of the communication
And
in that
further-
form.
Further, that can read.
No,
the
no, no.
second
I will
line
mold the
actually.
relief. Mold the
Okay,
relief.
great.
Now, there shall be the opposite parties shall remain restrained by an order of injunction from acting upon or giving any operation to the communication dated April 11, 2025, which has been impugned in the suit, comma, issued by the bank to the petitioners, and or from dealing with the property mentioned in Schedule A of the plaint, and or creating any third party interest, and or changing the nature and character of the said property in any manner whatsoever till September 15, 2025, or until further order, whichever is earlier. Whichever is earlier. Liberty is granted on the prayer of learned counsel for the petitioners to amend the prayer portion of the revisional application to that effect. Please, Mr. Ghosh, you personally supervise this. Whatever I have granted, make it in line with that.
Excellent.
Fine. Yes, sir. I did not write it. Have I? I have not. I'll put it. Item 2 there. I'll put that in. Item number 2 কে নিয়েছে তন্ময় বোধহয় শুভকে বলে দিতে যে party shall act on the server copy tag. Next.
Well, I'm praying for next circle.
Why?
Mr. Mominur Rahman is appearing in this matter. Lordship, he is ill. Lordship, that's why unable to.
On the prayer of the petitioner, the matter is adjourned till the next circuit. You are appearing? Yes. This is no caveat is there for the first time.
Oh, my lord.
Yes. What is the matter, please?
Yes, my lord.
What is the matter?
Yes. Now, my lord, at the very outset, I would like to submit to lordship that the present application that I prefer in respect of an order passed by the additional district at session judge APC Court Siliguri
Yes.
in respect of an application under section 24 of Hindu Marriage Act. And by that order, the learned lower court, but as passed certain award in favor of the respondent wife. Now, being agreed with the said order, I prefer these questions.
It's your suit.
Yes.
Your suit. Suit for divorce.
Yes.
So she filed an enabling application. What is your ground of challenge?
Now, my lord, what I like to submit is the very inception.
Yes.
That this lady, that the wife, she has filed one application under the EV Act, 2005. Now, in that EV Act, my lordship, the lady swear one affidavit in terms of the judgment by Honorable Supreme Court.
Rajneesh versus Neha.
Rajesh versus.
Yes.
Now, in that affidavit, categorically stated what was the actual quantum each and every month she requests. And it is found that for 200,000 like that. Now, in terms of the said affidavit, and of taking hearing from both sides, the learned magistrate, as it is summary procedure, there was no scope for having any source of evidence of recording or evidence. So on the basis of the pleadings,
for both sides, the order passed by the learned magistrate awarding rupees 25,000 in favor of the wife.
There is no child of the marriage.
No, no.
Very well.
Now,
Then
that is against, though the wife claimed rupees 1,50,000, but she could not substantiate on what heads and what are the documents they could not produce some document for magistrate court. So naturally, the affidavits breakdown given regarding all the heads. So it was amounts to 41,000 and 25,000 has been awarded by the London magistrate. And that was not challenged neither of the parties.
no 45,000, 41.
45,000
Yes, 41,000. What you?
that he divided the heads, what all expenditures she needs, so that
That no that came to 41,000.
Yes, yes.
But granted 25,000. Why? Why not 41,000 ground?
because they put serious documents regarding the expenditures which he demand.
Acha.
Now, my lord.
Oh, she gave the breakup as 41,000.
Yes.
Acha. 25,000 granted. Very well. Yes. Then
Now, that order not been challenged neither by the husband nor by the wife. So it is admitted position or it can be deemed that he is very much satisfied with the said award which was passed by the Honorable Magistrate. Now, when the husband filed the matrimonial suit under 13 of the Hindu Marriage Act, in the same case, she has filed another application under 24 of the Hindu Marriage Act, claiming financial support, and in the same proceedings, that is 24 of afflictions, she has also filed an application taking the same.
but I don't find any reason given by the trial court.
Yes.
It appears to be because the italics portion is the judgment. Judgment is quoted. Rajanesh versus Neha has been quoted. Previously, PWDV Act has been quoted, and court holds that hence on the above considerations, it appears that the petition is entitled to alimony over and above, and the reason is very cryptic apparently. The second last page of the order, if all the circumstances are taken into account, it would appear that directing 1,50,000 would not be proper. And the reason is a just balance would be struck if the opposite party is directed to pay 50,000. This much.
This much. So what I understood.
Did both of you file your affidavits of assets in connection with the section 24 also? That was not apparently not considered.
That my application is very clear. That I have made the breakdown of the entire of my income.
No, where is the consideration? I don't see the consideration there.
Tax.
No, there is something.
Only 25,000.
The third page of the.
Only made double of the award which was passed
No,
by
second page of the order, if you come, I firstly look into the question as regards income of petitioner. Something has been stated. Let us look into that. No, it has been considered, not that not.
No, actually, what I agree. Why I agree? Because, my lord, I have made certain documents filed before the learned
Decision.
matrimonial court that she is a working lady, and that document was not considered.
What does she do according to you?
And this is a content writer. She earns certain money. And
Content
that
writer on the over the internet or?
internet of the company, and that document also filed before the matrimonial court also.
She disclosed her income from that.
No, she suppressed.
What is her stand? She does not work there.
She never challenged that document, never made in whisper, never made in supplementary.
What document did you produce to show that she was? IC Tales.
Yes, ma'am. And that is also reflection has been given in the order.
No, I am seeing from the order only.
Yes,
I have
ma'am.
not seen that document.
It has been mentioned of clearly that she is working like but anti-stress court finds that I am not in position to accept.
Oh, you filed a certificate issued by IC Tales.
Yes, madam. So the document ignored by the learned trial court.
Oh.
She never given it for judicial consideration.
No, what is the reason given?
At this stage.
Learned advocate for the OP has filed a copy of certificate allegedly issued, but such it cannot be regarded as a cogent proof.
So if the evidence would have been
So I'll stay the operation of this order, direct to serve copy, but subject to your going on paying that 25,000. Now I'll make it in part of my order. That will be the condition. Learned counsel for the petitioner, husband, has made out a strong prima facie case for hearing the revisional application on merits, full-stop. By the impugned order, in a divorce suit filed by the petitioner husband, the learned trial judge has granted alimony to the tune of rupees 50,000 per month, payable by the petitioner to the opposite party wife as alimony pendentility under section 24 of the Hindu Marriage Act. Full stop, next para. It transpires from the impugned order that although in his affidavit, comma, the petitioner husband categorically disclosed a certificate of income of the opposite party wife from as a content editor of a concern named IC Tales, ICYTALES, Purota block. IC Tales, comma, the same was brushed aside by the learned trial judge without giving a line of reasoning for doing so. Because of that apart, comma, in the portion where the learned trial judge grants the alimony, comma, no clear reason is reflected, pushed up. The learned trial judge merely held that if all the circumstances are taken into account, within bracket, without clarifying the circumstances, bracket closed, comma, it would appear that directing the opposite party husband to pay a sum of rupees 1,50,000 per month, comma, as paid by the wife, would not be proper. Full stop. However, comma, the learned trial judge proceeds, comma, without attributing any further reason to observe that a just balance would be struck if the present petitioner husband is directed to pay a sum of rupees 50,000 per month to the opposite party wife. Full stop. The amount was directed to be set off from rupees 25,000 per month already granted in connection with a proceeding under the domestic violence. What is the full name of the domestic violence? I forget every time. Protection of Women from Domestic Violence. Under the Protection of Women from Domestic Violence Act. Push up next para. Yes. Furthermore, comma, it transpires that since on the self-same yardsticks, comma, the appropriate forum under the said act had granted an amount of rupees 25,000, comma, the learned trial judge does not even consider whether there has been any change of circumstances in the interregnum to double the amount of maintenance, alimony, in the civil proceeding. Full stop. The revisional application shall be heard on the above questions. Full stop. The petitioner shall serve a copy of CO number 141 of the opposite party indicating that the matter shall be listed before the appropriate learned single judge in the next circuit when an affidavit of service shall be filed by the petitioner husband. Full stop. There shall be stay of operation of the impugned order bearing order number 9 dated April 16, 2025, passed by the learned additional district judge, fast track court at Siliguri in miscellaneous case number 10 of 2024, arising out of, what is the matrimonial suit? Arising out of matrimonial suit is 416. Arising out of matrimonial suit number 416 of 2023 till disposal of the present revisional application, comma, subject, however, comma, to the petitioner going on paying the monthly amount of rupees 25,000 as directed under the Protection of Women from Domestic Violence Act. Stay of operation subject to your going on paying that 20. None appears for the part. Yeah, you're praying for next circuit. On the prayer of the, please give your name. On the prayer of the petitioner, the matter is adjourned till the next circuit. Only your name, not your senior's name. Yes. 15, who is appearing? Mr. Rai is leading you?
15, my lord, in this matter, my lord, I am appearing.
Yes,
I
Mr.
am
Rai.
appearing for the petitioner.
Right. What is the matter?
This is a suit for it is suit for specific purpose of contract where
yes,
my application for addition of party has been rejected. It is not a case that I got the property subsequent to filing of the suit, but I am the owner of the property and portion already in my name. But the contract was entered between the parties, between the plaintiff and the defendant in respect of the entire area. That your lordship will
no, you are the plaintiff.
Page. No, I am the applicant.
You want to get
filed an
yourself
application
imputed
for,
as a party.
Yes, yes. Because
what is your
the
premise?
contract, yes, the property in respect of which the contract was entered between the plaintiff and the defendant is the entire property. But out of which I have also.
পরের ম্যাটারটাই আমার
Yes.
And
That
all the
does not apply
properties
to you. That whatever he
No.
said does not apply to you.
that I am also the owner of a portion of that property, but the contract entered between the plaintiff and the defendant is the entire property has been made. That's why suit was filed for specific purpose of contract of the entire property. That's why I filed an application for addition of party. If your lordship may can turn to my application for addition of party, which is at page 49. Well, got it?
Yes, 49.
Paragraph 10, that is at page 51.
Yes.
Marat will find paragraph 10, I have categorically stated that what is my interest in respect of the property in question.
Yes.
Marat got
Yes,
it.
yes.
Now if you lordship can turn to page 110. Yes. Now Marat can turn to counterclaim, page 110. The portion of the counterclaim I am not drawing attention to the entire counterclaim, the relief paid for. The entire declaration in respect of the entire property. My lord got it.
So what is the relief in the counterclaim?
Relief, my lord, will find 110, my lord. The declaration.
Not 110,
113. 113. It starts with
minus 10, Mr. Dry. Minus 10.
Always minus. Now, my lord, kindly consider the order impugned. On the premises I have said, my lord, kindly consider the order impugned. The order impugned, the learned trial court proceeded as if I am claiming
Your
title.
counterclaim, there is no prayer in your counterclaim as such. There is
No, it is not my counterclaim. It is
No,
the counterclaim of the defendant, where I am satisfying your lordship that in the counterclaim the entire property has been incorporated. That is the only thing I want to satisfy your lordship. It is not a case that I got the property or interest after filing of the suit. I'm not a
Mr. Rai, you can file a separate suit. You are not a proper party. File a title suit, declarated suit. The counterclaim which has been filed, no clear relief.
There is a counterclaim, but original suit for received purpose of contract along with coupled with my lord delivery position. My lord knows better than us, my lord. So even if my lord I am the owner, then I have to relegate to another proceedings. Either I have to file an application under order 2099 to 101. I have semblance of right in the property. It is not a right created subsequent to the filing of the suit. If I have right to the property and that is the subject matter of dispute, whether I am a necessary party or not. It is not a subsequent to the suit. I am claiming to somebody else. I am independent.
Where is the relief claim? In the suit.
In the plaintiff's
plain.
In the suit, my lord. Once, my lord. If your lordship can turn to.
Yes. Specific purpose of contract, register the land. Possession has not been separately claimed,
But it is ultimate. If your lordship can consider the position, your lordship can consider the position in a specific purpose of contract suit.
Provided contract was possession was not given to the plaintiff in terms of the agreement.
So it is a matter now because I am the owner of the property. I am claiming to be the independent. I have a semblance of right in the property.
Mr. Rai, what is this other written statement? What you placed is a different thing. Page 32, page 27.
Page 27 is the initial written statement. My lord, if your lordship can read page 27.
Yes.
It is a statement on behalf of the defendants. There your lordship will find.
What you placed something else 113. What is that?
No, that is amended. That is subsequently, my lord, the additional written statement that your lordship will find page 35. My lord, got it?
Yes. 35
now, my lord, can turn.
Yes.
Yes. Subsequently amended plate. Next, annexure C, page 38.
No,
now, corresponding to that.
You place something 110, 113.
110 is the counterclaim along with this is the now, my lord, this is the amended print. So after amendment, it starts from, my lord, page 38. My lord, got it? Page 38.
Page 38 to 101.
No, page 38, my lord, is the amended print. Subsequently, it was filed. And there your lordship kindly consider the prayer. The entire relief has been claimed and scheduled. The entire property has been incorporated. 4 acres of land. Schedule A, my lord, got it?
But still, Mr. Rai, I have some doubts whether you are an essay party in this suit. You can file a
My
suit.
lord,
File a
my lord,
suit
then
and file
I
an
have-
injunction there. This will be your cause of
Then-
action, this specific suit.
once, unless and until the suit is degreed or in other way, my lord, I have to sit in the after the fence, my lord.
You can file a suit seeking declaration of your title, and you can. This will be the cause of action of your suit that your person is title is jeopardized.
There is no document. It is an interstate document, unregistered document. One can consider it that way also.
That is a
Then I
different
have to
thing.
challenge a document which is not.
Why should
Yes,
you
that is
challenge
why.
any document?
Whether a semblance of right.
Why should you challenge a document? It does not govern you at all. It's an agreement only. Does not bind you.
Yes, this is a contract based on the document. Agreement.
Contract
So
does
this is
not
an
displace
agreement.
your title. If it was a deed, then you had to challenge it. Agreement creates only an actionable claim subject to
Yes.
specific performance degree being granted. Unless a degree is passed, you don't have a cause of
I am.
action.
That is why precisely when unless until degree is granted, I do not.
No, scope of court is correct, Mr. Mr. I file a suit, separate suit. No interference. Mr. Mukherjee, you want to add anything? So this is what I was wanting, Mr. Rai. The defendant in the suit has filed a civil suit against you. Go and file a counterclaim there. You already filed a counterclaim. Yes, Mr. Rai.
Yes.
Mr. Mukherjee has disclosed everything. What you are suppressing.
So then, Mr. Mukherjee, my lord, I am not suppressing, my lord.
There is already a suit against you. You have filed a counterclaim there. Go and fight there. Sorry.
Then, my lord, I have nothing to say.
Don't say. The present challenge has been preferred against the rejection of an application of the petitioner for the petitioner to be impleaded as a party to a suit for specific performance filed between the opposite party numbers 1 and 2, filed by the opposite party numbers 1 and 2 against the opposite party numbers 3 to 9. Next para, learned counsel for the petitioner argues that the learned trial judge acted without jurisdiction in refusing the amendment application on several counts. Full stop. In the suit for specific performance, it is submitted, an agreement has been pleaded and sought to be directed to be performed, which covers the entire property, to which the present petitioner also has ownership rights. Next para, hence, it is argued that if the suit for specific performance is decreed and a sale deed is executed in terms of the agreement, as an automatic corollary, possession of the petitioner would be disturbed. Thus, the petitioner has a cause of action for impleadment in the present suit. Secondly, it is argued that in the suit for specific performance, the defendants therein have filed a counterclaim seeking relief of declaration of title, which would also jeopardize the title of the petitioner. Thus, in view of the counterclaim as well, the petitioner is a necessary party to the suit. Next para, on query, it is disclosed that there is already a suit pending at the behest of the defendants in the suit for specific performance against the petitioner, where the petitioner has also filed a counterclaim. Full stop. Next para. Upon a consideration of the impugned order, comma, I find no irregularity or material illegality or jurisdictional error in the said order. Full stop. The learned trial judge rightly came to the conclusion that the petitioner is neither a necessary nor a proper party to the suit, and in the event the petitioner is impleaded, comma, the scope of the suit would be unnecessarily enlarged. Full stop. Next para. The limited scope of a suit for specific performance is whether the plaintiffs are entitled to have a concluded contract specifically performed against the defendant. Full stop. Next para. The subject matter of suit is entirely the actionable claim based on the contract, and no corporeal title or right in respect of any immovable property is the subject matter of such a suit. Full stop. Unless a person is a party to the contract, comma, the said third party is hit by the doctrine of privity in being impleaded as a party to the suit. Full stop. In the present case, comma, the court still might have considered impleadment if the petitioner was a subsequent purchaser of the property whose impleadment in the suit might at least be justified on the ground that, comma, if not necessary, comma, he would be a proper party to the suit. Full stop. Next para. However, comma, in the present context, comma, the petitioner's claim is based entirely on title to the suit property and title to the property, and as such, comma, is such claim is entirely beyond the limited scope of a suit for specific performance. Full stop. Thus, moreover, comma, the counterclaim as sought to be pointed out to this court is absolutely vague in nature, and there is no prayer portion of the counterclaim apart from declaration and injunction in terms of the averments made in the counterclaim, comma, which is neither here nor there. Full stop. Next para. In fact, comma, in the counterclaim, comma, it is stated that the defendants have suffered loss and damage for which the counterclaim was filed, comma, which does not, comma, in any matter, comma, pertain to the corporeal rights to the property which is the subject matter of the agreement. Full stop. Next para. In any event, comma, since there is already a pending suit for title in which a counterclaim seeking declaration of title has been filed by the petitioner, comma, there was no scope of impleadment of the petitioner in the suit for specific performance. Accordingly, I do not find any reason to interfere with the impugned order. CO 143 of 2025 is, comma, accordingly dismissed, comma, thereby affirming the impugned order bearing order number 70 dated March 17, 2025, passed by learned civil judge, senior division, Jalpaiguri, in OC suit number 102 of 1996. Title suit. What is the title suit? You have by hand inserted title suit? Oh. Then OC suit, no longer an OC suit.
No, title suit, my lord, is looking the title suit. Page one, the order impugned, your lord shall find.
Yes.
The title suit is between the parties that your lord shall find. Can you turn to page?
No, this order was passed in connection with what? The title suit.
OC suit. No, OC suit. Addition of party.
In bracket in
Title
the.
suit.
No, that is the CIS number. What is this?
CIS number is.
ওসি সুট না করে ওটা কেটে করে দিন।
Well, title suit 15/1 of 2017, my lord, page 92. Your lord shall find this is the suit filed by
ওসি সুটটা কেটে দাও। In title suit number 102 of 1996, bracket is 04/2016. Bracket closed. That is in the certified copies. No address to cost are the certified copies. Mr. Dhari, you are appearing in this matter? Next. Call.
And for the petition, I'm led by Mr.
Mr.
Sanjay Mukherjee.
Oh, yes. Yes, Mr. Mukherjee. Expertise, Mr.
My
Dhar.
lord, in this matter, my lord,
Yes.
in this, there is no caveat.
Acha,
In
right.
this matter, I am for appearing for the plaintiff. Plaintiff is the petitioner before lordship in a suit for declaration and injunction and recovery of possession.
Right.
In that suit, I filed the suit. Lordship kindly sees the orders. I filed the suit on 23rd April 2025. On the same date, the ad interim order of injunction granted, status quo directed. Lordship kindly comes to the 9th June order. That 9th June order, there are two orders, one handwritten, one typed. I request my learned friend, Mr. Dhar, to read out the handwritten order because in my scan copy, it's little unreadable.
Page 51, Lordship. Handwritten one is a
9625, yes.
Yes, yes.
Read out.
Handwritten
Yes,
portion.
SR of the service written of defendant number 1 and 2. Thereafter, Lordship, I also have this two lines.
No, you have to read every word.
I could not read.
No, otherwise there's no order.
Subsequently,
Choice is yours, Mr. Dhar. Unless you read each and every word, I won't pass any order.
and excuse me, for two lines, the next one, Simatika defendant number 2 appeared by filing Vakalatnama. Defendant number 2, Rustam Kundalia is not appeared. Issue notice upon the defendant number 2. A petition for extension of interim order has been
I
filed.
just don't understand which portion, relevant portions you are probably skipping.
No.
You read slowly.
I am reading slowly, Lordship. Page now 51 from the top, Lordship. SR of defendant number 1 and 2, Lordship. Thereafter 2-3 words I cannot. I also can read, Lordship.
You can't read the most portions of the order. Let us see the typewritten portion. Typewritten is a different order.
Typed order is different.
Different order.
Yes, that is the thing, my lord. The typed order which has come is completely different. Even the dates given are different. Lordship will kindly find the last two paragraphs. Fixed 2nd March 2026.
I cannot blame
For
the Calcutta much. If you're learned junior and I can't read, and you are obviously not reading. So he made a mistake. Whatever he felt, he wrote. Just like Mr. Dhar is reading. Whatever he's feeling, he's reading.
No, fixed 2nd March 2026 for SR of defendant number 2.
Give me 2 minutes, Mr. Mukherjee. I'll just read the order.
My lord.
What are you challenging about the order? I've read the order. Service return. This Simatigga defendant number 1 has appeared by filing Vakalatnama. Defendant number 2 not appeared. Issue further notice upon defendant number 2. And a petition for extension of interim order has been filed. Prayer is allowed. Interim order is extended till next date. Fixed next date 2/3/2026 for SR for defendant number 2. Requisite in the meantime.
Lordship kindly reads the next line.
Next line, Lordship.
Subsequently, it is found that defendant number 2 signed in the Vakalatnama.
Signed the Vakalatnama. If that be the case, then learned advocate who is representing the defendant number 1 is also representing defendant number 2.
Yes. So what is the difficulty in that? Why so much ado about that?
My question is, I'm asking myself, my lord.
Why service on further service on 2?
Further service, number 1. And secondly, a fixed 2nd March of 2026. And then, my lord, comes to the typed order. SR of Simatigga and Rustam Kundulna, that is the defendant number 1 and 2 received after duly served. Both the summons received by Simatigga. A petition for extension of
I'll not entertain the writ petition. I'll say that the handwritten portion, and I'll dictate the handwritten portion. It will be a part of my order. I'll say this is the order, so no interference.
My lord, kindly sees the date fixed 27th October 2025.
That
The
is what I'm
court-
saying. That is what I'm saying. I'll dictate the entire handwritten order. That will be a part of my order. I'll say this is the order clearly, and the typewritten certified copy given to you is erroneous. So I say there is no scope of interference, and the parties shall proceed and the court shall proceed on the basis of this handwritten order.
My lord, typed order was not given in my prayer. It is available in the records.
I'll say that the court and all parties shall not proceed on the basis of the typed order. So there is no
In
scope of interference.
My lord, that will be against the petitioner. Why I'm humbly submitting, my lord? In the typed order, it says fixed 27th October 2025. The date is little preponed. Instead of March 26. And the written objection, written statement by defendant number 1. In the first order, there is no such direction even.
No, Mr. Mukherjee, this handwritten order is written by the court.
My lord, maybe not by the court officers.
So I'll not I'll just this is on merits. I mean, it's not clear. So I'll direct the court to clarify which is the correct order.
My lord, my principal prayer is expeditious, and the orders which are in incongruity with each other, the typed and the handwritten, that I wanted to point out. That is the reason
So
why
that
this
you had to
220
approach before the learned trial judge. You approach the trial judge and say which is the correct order.
Lordship kindly gives the liberty.
That liberty
And
I'll give.
also to expeditiously dispose it of.
Suit of 25, suit of 25, Mr. Mukherjee.
No, expeditiously dispose of, not the suit. Injunction application, my lord.
Injunction, you are the plaintiff.
I am the plaintiff.
So you are enjoying an injunction. Extension has been
I am
granted.
enjoying. It is a status quo order, but unless the
Extension
suit,
till next date. No. I don't find any urgency in the matter for
my
you.
lord, after 1 year.
The present the present application under Article 227 of the Constitution has been filed primarily to seek an expeditious disposal of the suit, an expeditious disposal of the injunction application pending at the behest of the plaintiff petitioner in the suit. Whose sub next para, learned counsel for the petitioner points out that there is palpable discrepancy between the two transcripts, one in computer print and one in handwriting, of order number 04 dated June 9, 2025. Full stop, next para. It is apparent from a bare perusal of the two orders that the two are utterly different. Full stop, next para. For example, in the handwritten order, it has been recorded that service return of defendant numbers 1 and 2 are received after duly served. Full stop. Then it goes on to say received by Sima Tigga, and Sima Tigga defendant number 1 is appearing by filing Vakalatnama. Full stop. It further records that defendant number 2 within bracket named bracket close has not appeared. Full stop. The court directs issuance of further notice upon defendant number 2, but at the last line of the order, again states that subsequently it is found that defendant number 2 has signed in the Vakalatnama, thereby indicating that the learned advocate appearing for the defendant number 1 appears for the defendant number 2 as well. Full stop. The court records in the handwritten order that a petition for extension of interim order is filed and the prayer is allowed, thereby extending the interim order till the next date, and fixes the next date on March 2, 2026. Full stop. However, the said date is fixed for service return of defendant number 2, which is inherently contradictory, since in the latter portion of the order, the court itself records that the Vakalatnama filed on behalf of defendant number 2 has also been signed by defendant number 2, thus obviating any necessity for further service on the defendant number 2. Full stop. The most important parts of the handwritten order are missing in the computer print version of the same. So more importantly, in the computer print, October 27, 2025 has been recorded to be the next date for filing written objection, written statement by defendant number 1. And it also records that the suit will proceed ex parte against defendant number 2. Full stop. Thus, there was complete confusion in the records of there is complete confusion in the records of the trial court in so much as there is gross discrepancy between two versions of the same order, which are both a part of the record, full stop. Next para, in any event, comma, the purpose of in any event, comma, since the suit is only of 2025 and the plaintiff petition is already enjoying an interim order of injunction stroke status quo, comma, I am of the opinion that it is still premature to direct expeditious hearing of the suit, full stop. However, comma, upon being approached by the petitioner, comma, in terms of this order, comma, the learned trial judge shall pass a proper order, comma, recording as to the exact contents of the of order number 4 dated June 9, 2025, and direct the records of the suit to be corrected by reflecting only the correct order which was passed on June 9, 2025. Full stop. It is, comma, however, expected, comma, that the learned trial judge shall endeavor to dispose of the suit as expeditiously as possible along with the connected applications. CO 144 of 2025 is disposed
Another
of
one.
with the above observations, no orders to cost.
Well, if Lordship kindly takes up the page 53, page 53 is the E-Court report, which shows that the next date is 23rd September 2026.
Approach the trial court, the records will be corrected. Add
Kindly-
to the leave is further granted to the petitioner to approach the trial court for rectification of any further gross contradictions in the records of the trial court and the orders recorded in the suit. Whosoever is so approached, comma, the learned trial judge shall deal with the issue and rectify the records immediately. Thank you.
I'm obliged, my lord. I'm obliged.
Next. देखिए
My lord, with respect to item number 17, my lord, kindly excuse me, my lord, the video is not working, my lord. I beg to appear on behalf of the petitioner. My lord, the only prayer before your lordship is my interim application has been kept pending, and the Honorable trial judge says that it will be heard along with the main application.
What is the application
Kindly
in the
look-
nature of? Yes.
My lord, section 8 proceedings, my lord, the interim custody I wanted. That is a prayer. Since there is an order of expeditious hearing, the learned trial judge says I'll hear it along with the main application. That's the impugned order. Kindly have a look at the order dated 19th of July 2025.
Original application means the your
The main guardians and what's yes, please.
your application itself.
Yes, please. I had a prayer for interim custody that is being ignored, and the date has been fixed, Lord.
Mr. Chatterjee, the date has been fixed on consecutive dates have been fixed for evidence of today. So
yes, for the main matter. For the main matter, Lord, I want interim custody of my child. There are many problems with my child. She has a mental problem. I can show that before your Lord. My interim application.
Where is the direction for expeditious hearing, Mr. Chatterjee?
Lord, your lordship will find that at page 64. It starts from 63, my lord. So this is with respect to the main suit. This doesn't mean, my lord, my interim application cannot be heard. With a lot of respect to the learned trial judge.
The prayer made in the present present application under Article 227 of the Constitution is innocuous, and as such, prior notice of service on the opposite party is dispensed with. Full stop.
May I have my lord's kind leave, my lord?
Yes. By the impugned order dated July 19, 2025, passed in Act 8 case number 02 of 2025, the learned district judge, Darjeeling, has directed the petitioner father's interim prayer for visitation stroke custody along with for hearing along with the main custody stroke guardianship application. Push up next para. This was done pursuant to a direction of a coordinate bench of this court to expeditiously dispose of the main proceeding. Push up. Learned senior counsel appearing for the petitioner argues that irrespective of the direction to dispose of the main matter, which can proceed in the meantime, the learned trial judge ought to have disposed of the interlocutory application first. Push up next para. from the impugned order, it transpires that the main matter has been fixed on consecutive dates being August 25, 26, 27 and 28 for evidence. Full stop. Next para. However, keeping in view that the conclusion and that the final disposal of the main matter may take some time despite consecutive dates for evidence being fixed, since further evidence and hearing of the matter and arguments will take place before the final disposal, the ends of justice demand that the interlocutory application filed by the petitioner is disposed of prior to the main matter. Accordingly, CO number 145 of 2025 is disposed of by directing the learned district judge at Darjeeling to dispose of the interlocutory application filed by the petitioner for custody / visitation in connection with Act 8 case number 02 of 2025 pending before the said court. Expeditiously, prior to disposal of the main Act 8 case, preferably within 4 weeks from the date of communication of this order to the said court. Next para, it is made clear that nothing in this order shall prevent the learned district judge from proceeding with the hearing of the main matter simultaneously as well, nor as to cost. Arjun তন্ময় অনিরুদ্ধ চ্যাটার্জি সিনিয়র অ্যাডভোকেট সঙ্গে লিখে দিও, যিনি অ্যাপিয়ার করছেন তার সঙ্গে। কে অ্যাপিয়ার করছে? রেকর্ডে কে আছে দেখে নাও। ব্যাকশিটটা দাও, ব্যাকশিটটা দাও।
Lordship, I am there appearing.
Give your names.
And Lordship, I've
Thank you. Thank you. Next. হয়ে গেছে পরে মাঠে বাবা। Yes. On the prayer of the petitioner. On the prayer of the petitioner, the matter is adjourned till next circuit. Next. 19. Same prayer.
Praying for tomorrow, Your Lordship. Listing for tomorrow, 19/20/21, Your Lordship. I'm for the petitioner.
On the prayer of the petitioner, the matter is adjourned for the day.
Listing tomorrow.
এটা কালকে আচ্ছা, on the prayer of the petitioner, let the matter be listed tomorrow. যেটা listed tomorrow বলছি সেগুলোই দিও, কাল ছোট করে দেব লিস্ট। Yes, with a trademark cuff. With a trademark cuff. Yes. Yes. What is the matter?
Mr. Lordship, I beg to appear on behalf of the petitioner.
Yes, Mr. Mukherjee, you are appearing. That means there is nothing in the matter. You are appearing means presumption is there is nothing in the matter. That's why you have been briefed. Anyway, sorry, Mr. Mukherjee. Sorry for that.
Maybe your Lordship will come to a different conclusion.
No, Mr. Mukherjee, yes, what is the matter, please? Sorry.
Lord, my client instituted a suit for eviction of a person who was alleged to be a licensee.
Right.
He was a caretaker of the property. He was residing there and he was a licensee. The defendant appeared, filed a written statement admitting that he was appointed a caretaker and was occupying the suit property, a portion of the suit property in that capacity.
Yes.
The suit was decreed on the basis of this admission. Then I filed the execution case. During the pendency of the execution case, they preferred an appeal. In the appeal, they prayed for stay. Stay order is annexed to Your Lordship. In our objection to the stay application, we pointed out that we had put and set up a 7-story building meant to be a hospital building, and only in a portion of it, the completion could not be done because of the defendant. The trial court has granted a stay. I grant Your Lordship that I am entitled to occupation charge from 2019 up to 2025. In spite of prayer, the court has not dealt with it. And secondly, court has fixed a date for hearing of the appeal. I was praying, my Lord, that in view of 4 years gone by and the huge investment I have made and the involvement of public interest in a hospital, Your Lordship will kindly fix a date within which the appeal itself is disposed of.
Seriously opposed?
So I also want to dispose of the appeal, my lord.
Obviously.
And may I submit, my lord?
Yes.
Actually, Your Honor, I've been cooperating with the respondent in the sense, my lord, that the appeals are heard only on Saturdays, Your Honor. My lord, it is a specific request of the.
You can honor me or lordize me, whatever. Yes.
Yes, my lord.
So what? Yeah. So then therefore no difficulty in directing the appeal to be disposed of within a limited.
Yes, my lord, there is an application order 6 to 17 also in between, my lord. That we dispose of. Then
Order 6 to 17, the amendment of what? Plaint? A written statement?
Yes, I may submit, my lord. May I submit, sir?
No, we have a right, legal right. That's not in doubt.
My lord. My lord, I am a owner of this property by way of a partition degree passed in favor of.
Order 6 rule 17. We all know the fate of it because 12.6 decree.
My lord, actually, let me come.
You are trying to change the entire.
No, my lord. Let me come to the crux of the matter, my lord. From 2014, I have been fighting a suit with the defendants, my lord, with the plaintiffs, my lord. There's no mention about that suit, my lord. Title suit number 147, my lord. In the suit, what had happened, my lord? They did not make me a party. They made Siliguri Municipal Corporation a party in the case, my lord. They got an order of status quo, got module.
Probably on because I can.
It's on, my lord. See.
It's on.
Is it on, my lord?
Yes.
They filed a suit against the Siliguri Municipal Corporation, my lord. They did not make me a party in the case, despite me being the owner of the property, my lord. Siliguri Municipal Corporation appeared. The Siliguri Municipal Corporation appeared, made a statement that we have nothing to do with the property, my lord. The order of ex parte status quo was.
Why are you saying these things? How are these material?
In that suit, my lord.
You are not deciding the 617 here.
Without trial. This degree is without trial, my lord. My order 6 to 17, the written statement which has been filed, my lord. Such a written statement cannot be filed by me, my lord. I have been fighting this suit from 2014, my lord. Driving the court in that suit has held.
So you allege fraud.
Yeah, alleged fraud, my lord.
Then you had to go before the trial court alleging fraud.
Yeah, I want to trial court, my lord. I've stated in my appeal, my lord, that the written statement which has been filed, my lord.
You have filed an appeal. You have not gone to the trial court. You did not file a suit challenging the decree on the ground of fraud.
My lord, just now in the last date, I got a stay on the judgment and degree, my lord. I've already prepared a suit for setting aside a degree, my lord. Because
you have filed an order 6 rule 17 application for amendment of your written statement in connection with the appeal. You have filed that application must be.
In connection with written statement filed before the trial court, my lord.
Obviously, written statements are always filed in the trial court. You have filed that application in the appeal, pending appeal. Mr. Mukherjee, an application under order 6 rule 17 is pending. We cannot decide that. So we can direct the trial court to decide that within say 4 weeks and the appeal.
It is pending in the trial court. It is pending in appeal. Trial court has to agree.
In a pending appeal, Mr. Mukherjee, your learned friend says he has filed an application under order 6 rule 17 for amendment of the plaint.
Appeal court will take care of it if it's maintainable.
Exactly.
He wants to withdraw the admission.
Yes, that I understand, Mr. Mukherjee. That is what I asked your learned friend also, but we cannot pre-decide that. Whatever may be the.
Court will deal with it.
So within 4 weeks that will be dealt with, and the appeal within say 6 weeks thereafter.
Grateful, Lordship.
Thank you.
Kindly pass this on.
Thank you. Learned senior counsel appearing for the petitioner submits that the petitioner obtained a decree under Order 12, Rule 6 of the Code of Civil Procedure on the premise of an admission made by the defendant stroke opposite party in a suit for eviction of licensee to the effect that the defendant stroke opposite party number 1 is a caretaker and as such a licensee. Next para, subsequently, an appeal has been preferred where an order of stay has been granted. However, no occupation charges were awarded to the petitioner as a condition of the stay. Learned senior counsel, however, submits that the petitioner would be satisfied in the event the appeal is disposed of early, since the petitioner has already constructed a 7-storied building where a hospital is proposed to be. You are already running that?
No, my lord, it couldn't be completed in that portion.
A 7-storied building is planned to be constructed on the suit property where a hospital will be operated, which will be of immense public interest. Thus, the appeal is required to be expedited. Next paragraph, counsel appearing for the defendant stroke opposite party number 1, who is the main contesting opposite party, submits that an application under Order 6 Rule 17 of the Code of Civil Procedure filed in connection filed no, an application on Order 6 to 17 of the Civil Code of Civil Procedure for amendment of the written statement has been filed in connection with the appeal by the defendant stroke appellant stroke opposite party number 1. First up, taking into consideration the rival contentions of the parties, it transpires that the appellant, the petitioner is justified in pleading extreme urgency in the matter in view of the proposed construction of a hospital on the suit property.
Construction is almost complete.
Which is almost complete. Full stop, next para, be that as it may, since an application, interlocutory application on Order 6 Rule 17 of the Code has been filed in the suit, in the appeal by the opposite party number 1, for amendment of the written statement, the same has to be decided first in accordance with law by the appellate court prior to the disposal of the appeal. Full stop. Accordingly, keeping on balance the urgency involved and the above factors, CO 151 of 2025 is disposed of by requesting the learned additional district judge.
There for occupation charge also.
You have made an application for occupation charges or the stay application?
In my objection, I paid for it.
Oh, stay application is still pending.
Stay application has been disposed of by granting stay.
Occupation charges, Mr. Mukherjee, if we direct that to be considered now, then you are challenging that, then I can direct the stay application to be reopened and that will take further time.
A huge amount, my lord.
True, Mr. Mukherjee, but two cannot go together. Either the
6 weeks thereafter. 4 weeks occupation charge. 6 weeks thereafter suit the appeal.
Occupation charge, because the stay application, it could only be a condition of the stay, Mr. Mukherjee. Now, if the stay application has already been disposed of.
Very well,
No, you take instructions, because then I can direct the stay application to be reheard on I'll set aside the order of stay, granting stay for a limited period and directing the question of occupation charges to be decided by the appellate court.
And then within a certain period, the student appeal to be disposed.
I'm ready for that, my lord. Piece of time for 2 weeks also, I'm ready for you, my lord. Occupation charges, I will not be able to pay, my lord. I will not be able to pay. Because they're poor, they're very poor, my lord. They're extremely poor, they're day laborers, my lord. If you are not supposed to fact of the case, my lord, is surprising, my lord. 1 week, 2 week, whatever time, my lord, as early disposal, I'm not, it doesn't matter to me.
Mr. Mukherjee, I'm telling you this. Suppose occupation charges are imposed. They don't pay the occupation charges. Then the stay, please. Then the stay is vacated.
It is meant for the appeal, another second appeal. If they want to have a stay in the second appeal, that will be my offense.
Yes. So let that, no, occupation charges had to be imposed. You pay or not pay, that's your problem.
May I submit one thing, my lord?
And that is settled. Attaram has been khaja chara long back.
I admit, my lord.
They admit.
It is occupation charge by rent, my lord. By rent, by the standard of rent, my lord.
I would not fix the occupation charges. I'll direct the appellate court to fix it. I'll reopen the stay order. I'll grant stay for the time being unconditionally, and এটা orderটা চেঞ্জ করে দিন. The present challenge has been preferred by the impugned order. Stay was granted or what?
Yes, my lord. Stay was granted, my lord.
By the very well. By the impugned order, the learned first appellate court has granted an order of stay in connection with an eviction decree passed in favor of the revisionist petitioner under Order 12 Rule 6 of the Code of Civil Procedure. Full stop. The suit was filed on the premise that the opposite party number 1, being a caretaker, is a licensee of the premises. Full stop. In the written statement, the opposite party number 1 admitted that he is a caretaker, and accordingly a decree was passed in the eviction suit on admission. Full stop. Subsequently, an appeal was preferred against the said decree, where the opposite party stroke appellant paid for an order of stay. Full stop. Such stay was granted by the impugned order without imposition of occupation charges. Full stop. Learned senior counsel for the petitioner submits that it is a well settled position of law since long that for grant of stay in connection with an eviction suit, a necessary precondition is imposition of occupation charges at the current market rates. Full stop. Next para. As such, comma, the impugned order, comma, it is submitted, comma, is vitiated on such score. Full stop. Next para. Learned senior counsel also seeks an expeditious hearing of the appeal, comma, since according to the petitioner, comma, the petitioner has started construction of a 7-storied building on the suit property, which will be utilized for operating a hospital, which will be of public utility. For some next para, learned counsel appearing for the contesting opposite party number 1 submits that there is a pending application under Order 6 Rule 17 of the Code of Civil Procedure for amendment of the written statement, comma, filed in connection with the appeal by the opposite party number 1. Full stop. That apart, comma, it is submitted that the opposite party number 1 is of meager financial condition and is not in a position to pay occupation charges. Full stop. Next para, be that as it may, comma, it is well settled that occupation charges are a necessary precondition of imposition of stay in an eviction decree. Full stop. Thus, comma, the learned appellate judge acted without jurisdiction in granting stay of an eviction decree without imposition of occupation charges upon assessing the current market rates. Next para, accordingly, comma, CO 151 of 2025 is allowed on contest against opposite party number 1 and ex party against the pro forma opposite party number 2, thereby setting aside the impugned order bearing order number 41 dated May 16, 2025, passed by the learned additional district judge, bracket, second fast track court, bracket closed, at Jalpaiguri in title appeal number 13 of 2022, and directing and remanding the stay application to the appellate court. First of the learned appellate judge shall now rehear the stay application on the question of occupation charges to be imposed as condition for grant of stay. First up, there shall be unconditional stay of the eviction decree for a limited period of 4 weeks. First up, the learned first appellate court shall dispose of the stay application. Stay application 4 weeks na kore 6 weeks ওটা করে দিন আগে stay application including imposition of occupation charges upon hearing both parties, comma, within a fortnight from the date of communication of this order to the appellate court. Within 3 weeks করে দিন fortnight to the appellate court. Full stop. Next para, the learned first appellate court shall, comma, immediately thereafter, comma, dispose of the application under Order 6 Rule 17 of the code pending at the behest of the opposite party number 1 in connection with the appeal, comma, upon granting adequate opportunity to both parties to exchange their pleadings on the said application and hearing both parties. Full stop. Such disposal of the Order 6 Rule 17 application shall be completed preferably within 3 weeks from the date of disposal of the stay application. Full stop. It is further expected that the learned appellate judge shall dispose of the appeal itself as soon thereafter as possible, comma, preferably within 4 weeks from that date, from the date of disposal of the application under Order 6 Rule 17 of the code. Full stop. Next para, it is made clear that this court has not entered into the question of quantum of occupation charges, and it is left open to the first appellate court to decide on all issues involved in the appeal, including the question of occupation charges, independently and in accordance with law. Next para, all parties as well as the learned first appellate court shall act on the basis of the server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance of the same. No orders to cause urgency. Thank you. Next.
Great, Your Lordship.
Thank you, sir. Yes. Yes. None appears for the parties. Next circuit. Adjourn till next circuit. হ্যাঁ যার আছে রাখো, আরেকটা দুটো রাখো, আছেন তুমি যত রাখো। ইয়েস, সবই তো প্রায় কন্টেস্টেডই হচ্ছে। ইয়েস মিস্টার দত্ত, বরঞ্চ কন্টেস্টেডটাই দেখবে, কেউ নেই আদার সাইডে। Yes, Mr. Datta, what is the?
The fact of the case is that the plaintiff and defendant number one are the partners.
Acha, the opposite party has not appeared on the previous occasion. Before dismissal for default also no copy was directed.
The copy was served on upon.
They were appearing?
On restoration date, they appeared.
Oh, yes. So should we wait for them? Are you enjoying an interim order? No.
I am enjoying an interim order.
Without them, should you hear it out? You want the bench, but the opposite party does not.
Actually, the matter is that that has been kindly see the order. Actually, total on wrong contention, the order has been made.
What is the order? Tell us. Tell me.
Order is
No, just verbally tell me, Mr. Datta.
actually the plaintiff and defendant number one are the partners, and the
Mr. Datta, since Mr. Vikas Singh along with Mr. Bhattacharya were appearing, just give a notice that what will a notice do? I mean, it has to go to the next. Tomorrow, I can make it to, not today only. Tomorrow there is. You can give a notice to the other side. Very well. The matter is none appears for the opposite party, although the petitioner is represented through counsel. Full stop. Accordingly, let the matter stand adjourned for the day. Full stop. The learned advocate for the petitioner shall give a notice to the to his counterpart for the opposite party as to the matter being fixed tomorrow. Full stop. In the event the opposite party is absent tomorrow, when the matter is called on for hearing, comma, appropriate orders may be passed in the absence of the opposite party. Give a notice immediately. কালকে থাকবে এটা। যেগুলো বলছি শুধু সেগুলো থাকবে কাল। বাকি টাকা থাকবে। None appears for the parties. Adjourn till the next side.
Item number 26
Petitioner. On the prayer of the petitioner, let the matter stand adjourned till the next circuit.
Item number 26.
Lordship, rise, Lordship. Yes, Lordship. Actually, my four matters are running in the list every day.
Which matters?
MSSC application matters. Only application. Delay. Section 5 application. Lordship.
Section 5. You have served on the other side.
Yes, Lordship. FATV service there.
Which ones? Tell us.
48, 45, 45, 49.
Let me note করে নাও
50, 51.
45, 45, 9, 50, 51. 45 and 49 to 51.
Right.
এগুলো কালকে দিয়ে দিই।
Lordship, my Lordship at that one is 44. That is served and everything is ready.
44 টা কালকে দিয়ে দিই।
Lordship, Lordship may be permitted.
It's already 4:30. For tomorrow, 38. Other side is there.
Lordship, I am appearing. I can number 38 my lord for the petition.
38 টা কালকে দিয়ে দাও। না,
My lord,
বড়
item
matter,
number
এটা নয়।
27.
27, that is a continuing matter that will take some time. Cannot fix tomorrow, sorry.
My lord, would that be in the next circuit bench?
It will automatically go. 43, what is the matter?
Public.
43, 43. ব্যাস আর না, চলো।